Chapter I Overview of International Covenants, Constitutional Provisions, Laws, Rules and Regulations on Environmental Justice. 01. Introduction. In 1994, the astrophysicist Carl Sagan wrote a book describing the journey into space of the Space Shuttle Voyager ride. During that voyage, scientists took a picture of the Earth from the outer reaches of the universe. What the scientists saw was a pale blue dot within the vastness of a dark and infinite universe. That dot represents the totality of the human race, of everything that is known to us, of everyone who means to us, and of everything that sustains us. That dot is the only planet we call home. Yet man has lived as if he is the center of the universe, and that the bounty of that pale blue dot, the planet which he calls home, is infinite. Throughout history, humanity's attitude towards the Earth has been one of conquest and exploitation. We are at that point in our history where the awesome powers and efficiency of our technology are only matched by our greed for resources to suit our needs and comfort. Today, the consequences of man's actions or inactions on the environment, devastating floods, unprecedented global warming and extreme weather conditions, powerfully but tragically demonstrate the need for accountability and faithful adherence to the laws on the environment. These laws are the expression of society's collective commitment to protect and preserve the environment. The rule of law is therefore a basic premise of our common survival as a species. In Association of Small Landowners in the Philippines versus Secretary of Agrarian Reform, Justice Cruz wrote about the Mother Earth as the giver of life, thus. In ancient mythology, Antaeus was a terrible giant who blocked and challenged Hercules for his life on his way to Mycenae after performing his 11th labor. The two wrestled mightily and Hercules flung his adversary to the ground thinking him dead. But Antaeus rose even stronger to resume their struggle. This happened several times to Hercules' increasing amazement. Finally, as they continued grappling, it dawned on Hercules that Antaeus was the son of Gaia and could never die as long as any part of his body was touching his Mother Earth. Thus forewarned, Hercules then held Antaeus up in the air, beyond the reach of the sustaining soil, and crushed him to death. Mother Earth, the sustaining soil, the giver of life, without whose invigorating touch even the powerful Antaeus weakened and died. 02. Environmental degradation. From a global perspective, the environment has continued to degrade and several environment problems remain deeply embedded in the socio-economic fabric of nations. At present levels of industrial activity, greenhouse gases are expected to cause permanent increase in temperatures. The consequences of a warmer world, rising seas and extreme weather conditions, have caused untold suffering on the world's peoples. The world's oceans are overfished. Its forests are heavily denuded. The current environmental situation places the Philippines at the hottest of the biodiversity hotspots. Climate change has also its pernicious consequences. As one observer succinctly states, climate change represents the most serious, most pervasive environmental threat that the world faces. The issues are not merely scientific. Climate change spans political, social, and economic dimensions, crosses national boundaries and reaches beyond the present degeneration. It will aggravate the complex problems of development that we struggle with today, like poverty, food security, and water availability that threaten to ignite large-scale political and social upheavals. The Philippines' remaining biodiversity and the ecosystems that support it are under tremendous threats. Extractive industries, such as logging and mining, have destroyed most of the forests. High human population density and growth rate further put enormous pressure. Rainforests have been converted to agricultural land plantations to augment land needed to support a growing population. Cyanide and dynamite fishing, along with rapid development in coastal areas, continue to destroy coral reefs and mangroves. 03. Environmental justice. Environmental justice means the fair treatment and meaningful involvement of all people regardless of race, color, national origin, or income with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. It affirms the sacredness of Mother Earth, ecological unity and the interdependence of all species, the right to ethical, balanced, and responsible uses of land and renewable resources, the right of all workers to a safe and healthy work environment, and the need for urban and rural ecological policies to clean up and rebuild our cities and rural areas in balance with nature. 04. International agreements and conventions. To the present generation's credit, significant progress has been made in confronting environmental problems in developing and industrial nations. Worldwide, the greatest progress has been in the realm of institutional developments, international cooperation, public participation and the emergence of private sector action. Of these developments, the construction of legal frameworks, as part of institution building, is particularly important because the law is increasingly being used, internationally and domestically, to express society's value for environmental protection. We have seen in the past several years a veritable explosion of international agreements and national legislation seeking to protect the environment. The 1972 Stockholm Declaration, regarded as the foundation of modern international environment law, was the first widely accepted international effort to address environmental issues. In 1983, the Brundtland Commission's report espoused the concept of sustainable development, thereby recognizing the necessary linkage between the environment and economic development. The 1992 United Nations Conference on the Environment and Development, UNCED, led to the Rio Declaration on the Environment and Development as well as Agenda 21, this generation's international blueprint on environment. Principle 1 of the Rio Declaration states, human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. A historic UN climate conference ended on December 19, 2009 with a non-binding Copenhagen Accord, a deal short on concrete steps against global warming, but signaling a new start for rich poor cooperation on climate change. On September 11, 2009, representatives from more than 20 Asian countries, including the Philippines, adopted the Manila Declaration on Resources Efficient and Green Industry, an initiative which promotes low-carbon business systems and operations. While the Manila Declaration is a non-binding document, it outlines the steps needed to reduce resources intensity and carbon emissions of Asian industries. These international agreements, conventions and protocols on the environment include Rio Declaration on Environment and Development recognizing the integral and interdependent nature of the Earth. The nations meeting at the Earth Summit in Rio de Janeiro adopted a set of principles to guide future developments. Human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. States have the sovereign right to exploit their own resources pursuant to their own environmental and developmental policies, and the responsibility to ensure activities within their jurisdiction or control do not cause damage to the environment of other states. Nations shall develop international laws to provide compensation for damage that activities under their control cause to areas beyond their borders. Nations shall use the precautionary approach to protect the environment. Where there are threats of serious or irreversible damage, scientific uncertainty shall not be used to postpone cost-effective measures to prevent environmental degradation. Nations shall cooperate to conserve, protect and restore the health and integrity of the Earth's ecosystem. Nations shall enact effective environmental laws, and develop national law regarding liability for the victims of pollution and other environmental damage. The polluter should, in principle, bear the cost of pollution. Environmental issues are best handled with the participation of all concerned citizens. States shall facilitate and encourage public awareness and participation by making environmental information widely available. Nations should reduce and eliminate unsustainable patterns of production and consumption, and promote appropriate demographic policies. Agenda 21 is a program of action into the 21st century for bringing the Earth into a sustainable future. It was adopted by the participating governments of the world in the United Nations Conference on Environment and Development, UNCED, otherwise known as the Earth Summit, in Rio de Janeiro, Brazil in June 1992. Agenda 21 details an action plan for sustainable development and establishes targets for actions that combine economic development and environmental protection. Philippine Agenda 21 is the Philippines' commitment to the UNCED. It lays down the mix of strategies that integrate the parameters in the country's overall development strategy, identifies the intervention areas, or action agenda, from the national to the regional level, with the corresponding implementing platforms and plans. PA21 is our own national agenda for sustainable development. Enhanced PA21. PA21 was updated into the enhanced PA21, particularly noting that the rise of globalization and the creation of an external environment of finance, markets, and technology did not seem conducive to sustainable development. Civil society needs to specify its commitments and contributions achieving sustainability in the updated document, and government departments need to be imbued with the sustainable development perspective with which to handle issues properly. UN Conference on the Law of the Sea, UNCLOS, also called the Law of the Sea Convention. UNCLOS is the international agreement that resulted from the Third United Nations Conference on the Law of the Sea, UNCLOS III, which took place between 1973 and 1982. The Law of the Sea Convention defines the rights and responsibilities of nations with respect to their use of the world's oceans, establishing guidelines for businesses, the environment, and the management of marine natural resources. UNCLOS I creates a sui generis maritime space, the exclusive economic zone, granting new rights to coastal states to exclusively exploit the resources found within this zone up to 200 nautical miles. It provides that states have the obligation to protect the marine environment and that only the adjacent coastal state has the right to create artificial islands, or erect structures on LTAs within its seas or CS. It also obligates state parties to take all measures necessary to ensure that activities under their jurisdiction or control are so conducted as not to cause damage by pollution to other states and their environment. Pacific International Lines Philippines-China Sea Dispute Award. In a unanimous award dated July 12, 2016 on the compulsory arbitration instituted by the Republic of the Philippines against the People's Republic of China, the Permanent Court of Arbitration declared that certain sea areas like the Spratly Islands and Scarborough Shoal are within the exclusive economic zone of the Philippines because those areas are not overlapped by any possible entitlement of China. The tribunal concluded that there was no legal basis for China to claim historic rights to resources within the sea areas falling within the 9-dash line as such were extinguished by, and were incompatible with, the exclusive economic zones provided for in the UNCLOS. The tribunal also found that China has violated the Philippines' sovereign rights in its exclusive economic zone by a. interfering with Philippine fishing and petroleum exploration, b. constructing artificial islands and c. failing to prevent Chinese fishermen from fishing in the zone. The tribunal also held that fishermen from the Philippines had traditional fishing rights at Scarborough Shoal and that China has interfered with these rights in restricting access. The tribunal considered the effect on the marine environment of China's large-scale land reclamation and construction of artificial islands at 7 features in the Spratly Islands and found that China had caused severe harm to the coral reef environment and violated its obligation to preserve and protect fragile ecosystems and Vienna Convention for the Protection of the Ozone Layer, concluded in 1985. It is a framework agreement in which states agree to cooperate in relevant research and scientific assessments of the ozone problem, to exchange information, and to adopt appropriate measures to prevent activities that harm the ozone layer. Montreal Protocol for the Protection of the Ozone Layer, This treaty is designed to protect the ozone layer by phasing out the production of numerous substances that are responsible for ozone depletion. It was adopted on September 16, 1987, and entered into force on January 1, 1989. Copenhagen Accord. Here, all of the world's developed countries and the biggest developing countries agreed, for the first time, to put limits on their greenhouse gas emissions. The emissions reductions agreed on were still not enough to meet scientific advice, but they were a big advance on reducing emissions compared with business as usual. UN Framework Convention on Climate Change. This agreement binds governments to take action to avoid dangerous climate change, but did not specify what actions. The Philippines expressed adherence to the principles of sustainable development and environmental preservation. In 2000, it forwarded to the UNFC its initial national communication which enumerated the accomplishments of the country in the fields of greenhouse gas abatement and inventory. In October 2015, the Philippines submitted its new Climate Action Plan UNFC ahead of the 2015 Paris Summit. Kyoto Protocol. This treaty extends the 1992 United Nations Framework Convention on Climate Change, UNFC, that commits state parties to reduce greenhouse gases emissions, based on the premise that, a. global warming exists and, b. man-made CO2 emissions have caused it. The Kyoto Protocol implements the objective of the UNFC to fight global warming by reducing greenhouse gas concentrations in the atmosphere to a level that would prevent dangerous anthropogenic interference with the climate system. Article 2. The Philippines signed the treaty on April 15, 1988 and ratified it on November 20, 2003, Basel Convention. This treaty is designed to reduce the movements of hazardous waste between nations, and specifically to prevent transfer of hazardous waste from developed to less developed countries. Ldc Paris Summit. The governments of more than 190 nations, including the Philippines, gathered in Paris from November 20 to December 11, 2015 to hammer out new global agreements aimed at reducing global greenhouse gas emissions and thus avoiding the worst impacts of climate change. The agreement sets out a global action plan to put the world on track to avoid dangerous climate change by limiting global warming to well below 2 degrees Celsius. The agreement was ratified by the Philippines in April 2016. All these international agreements, protocols, and conventions provide and mainstream a greater sense of importance and urgency on the issue of environmental protection. 05. Philippine environmental laws and issuances. The purpose of our environmental laws is to maintain or create conditions that are conducive to a harmonious relationship between man and nature. Environmental laws protect nature and the environment from degradation while taking into account people's needs and general welfare. Sections 1 and 2 of the Presidential Decree No. 1151, otherwise known as the Philippine Environmental Policy, embody the purpose of our environmental laws. Section 1. Policy. It is hereby declared a continuing policy of the state, a. to create, develop, maintain and improve conditions under which man and nature can thrive in productive and enjoyable harmony with each other, b. to fulfill the social, economic and other requirements of present and future generations of Filipinos, and c. to ensure the attainment of an environmental quality that is conducive to a life of dignity and well-being. The legal foundation of Philippine commitment to environmental protection and the preservation of our natural resources is contained in the Republic's Constitution of 1987. A. Constitutional Provisions 1. Article 1. The national territory comprises the Philippine archipelago, with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. 2. Article 2, Section 15. The state shall protect and promote the right to health of the people and instill health consciousness among them. 3. Article 2, Section 16. The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. 4. Article 12, Section 2. All lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. XXX The state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. The Congress may, by law, allow small-scale utilization of natural resources by Filipino citizens, as well as cooperative fish farming, with priority to subsistence fishermen and fish workers in rivers, lakes, bays and lagoons. The President may enter into agreements with foreign-owned corporations involving either technical or financial assistance for a large-scale exploration, development, and utilization of minerals, petroleum, and other mineral oils according to the general terms and conditions provided by law, based on real contributions to the economic growth and general welfare of the country. In such agreements, the state shall promote the development and use of local scientific and technical resources. 5. Article 12, Section 5. The state, subject to the provisions of this Constitution and national development policies and programs, shall protect the rights of indigenous cultural communities to their ancestral lands to ensure their economic, social and cultural well-being. The Congress may provide for the applicability of customary laws governing property rights or relations in determining the ownership and extent of ancestral domain. 6. Article 13, Section 7. The state shall protect the rights of subsistence fishermen, especially of local communities, to the preferential use of the communal marine and fishing resources, both inland and offshore. It shall provide support to such fishermen through appropriate technology and research, adequate financial, production, and marketing assistance, and other services. The state shall also protect, develop, and conserve such resources. The protection shall extend to offshore fishing grounds of subsistence fishermen against foreign intrusions. Fish workers shall receive a just share from their labor in the utilization of marine and fishing resources. 06. Laws and administrative issuances. There also exists a panoply of legislative acts and executive issuances which implement the constitutional edict. The country's laws on climate change adaptation, CCA, and disaster risk reduction, DRR, are acclaimed as the best in the world. 6. As early as 1979, the Philippine Environmental Policy 7 mandated the formulation of an intensive, integrated program of environmental protection that will bring about a concerted effort towards the protection of the entire spectrum of the environment through a requirement of environmental impact assessments and statements. The basic policy on the management and conservation of the country's natural resources is found in the Philippine Environment Code. The law provides for the development of standards and management framework for the following areas of concern: air quality management, water quality management and land use management. In a bid to protect the country's rich biodiversity, the National Integrated Protected Area System, NIPAS, Act 9 provides for the integrated management of all declared protected areas in the country. The revised Forestry Code is the governing law on forestry. Its basic policy is that the multiple uses of forest lands shall be oriented to the development and progress requirements of the country. We have a law requiring the planting of trees in certain places and penalizing unauthorized cutting or destruction thereof. The basic law on fisheries management and utilization is the Philippine Fisheries Code. 12 Its provisions apply in all Philippine waters and all other waters over which the Philippines has sovereignty and jurisdiction, the exclusive economic zone, the continental shelf and aquatic and fishery resources, whether inland, coastal or offshore. The Philippine Mining Act is the principal law on mining in the Philippines. It provides that all mineral resources are owned by the state, and aims to promote their rational exploration, development, utilization and conservation. The Indigenous Peoples' Rights Act embodies the policy of the state to recognize, promote, and protect the rights of indigenous peoples, IPs, to their ancestral lands and domains and ensure their cultural integrity. Pollution control is also recognized as a legitimate government concern under the Philippine Clean Air Act. 15 The law provides for a national program of air pollution management and prevention, and active public participation in air quality planning and monitoring. To revive the quality of fresh, brackish, marine waters in the country, the Philippine Clean Water Act 16 was enacted. Its focus is to streamline processes and procedures in the prevention, control and abatement of pollution of the country's water resources. The Ecological Solid Waste Management Act aims to adopt a systematic, comprehensive and ecological solid waste management program to ensure protection of public health and environment, set guidelines for solid waste avoidance and volume reduction, and ensure the proper segregation, collection, transport, storage, treatment, and disposal of solid waste. The Wildlife Resources Conservation and Protection Act 18 declares as a policy of the state to conserve the country's wildlife resources and their habitats for sustainability, with the objective of promoting ecological balance and biological diversity. The ownership, possession, sale, importation and use of chainsaws is regulated by the Chainsaw Act. 19. The government's policy to lead, promote, and accelerate the development and balanced growth of the Laguna Lake area and the surrounding provinces, cities, and towns gave rise to the creation of the Laguna Lake Development Authority. The Environmental Impact Statement System was established as a planning tool to avoid or minimize adverse environmental impacts of projects of government and private entities. The commencement of every environmentally critical project or project situated in an environmentally critical area has to be preceded by an Environment Compliance Certificate, ECC. The Biofuels Act 22 provides for the mandatory use of biofuels to help lessen emission of greenhouse gases, GHGs, that greatly contributes to global warming. The Climate Change Act of 200,923 establishes a climate commission which shall be the policy-making body of the government tasked to coordinate, monitor, and evaluate the programs and action plans of the government relating to climate change. The Philippine Disaster Risk Reduction and Management Act of 2010 institutionalizes arrangements and measures for reducing disaster risks, including projected climate risks, and enhances disaster preparedness and response capabilities at all levels. The Toxic Substances and Hazardous and Nuclear Wastes Control Act of 199,025 seeks to regulate or prohibit the importation, use and disposal of chemical substances that present unreasonable risk to health or the environment, and the entry of nuclear wastes and their disposal into Philippine territorial limits. The Philippine Environmental Policy declares as continuing policy of the state to create, develop, maintain, and improve conditions under which man and nature can thrive in productive and enjoyable harmony with each other. The National Caves and Cave Resource Management Act aims to conserve, protect, and manage caves and cave resources as part of the country's natural wealth. 07. Rules of Procedure for Environmental Cases. On April 13, 2010, the Supreme Court under the leadership of Chief Justice Puno approved the new Rules of Procedure for Environmental Cases. The rules are the end product of the valuable inputs from the Forum on Environmental Justice held through simultaneous video conferencing in Baguio City, Iloilo City, and Davao City. The rules took effect on April 29, 2010. Considered the first of its kind in the world, this landmark rule of procedure in environmental litigation is a significant catalyst in support of far-reaching and sweeping reforms in environmental justice and protection, and implements the power of the Supreme Court to promulgate rules concerning the protection and enforcement of constitutional rights and to provide a simplified and inexpensive procedure for the disposition of cases. A. Objectives. The rules of procedure have the following objectives: A. To protect and advance the constitutional right of the people to a balanced and healthful ecology. B. To provide a simplified, speedy and inexpensive procedure for the enforcement of environmental rights and duties recognized under the Constitution, existing laws, rules and regulations, and international agreements. C. To introduce and adopt innovations and best practices ensuring effective enforcement of remedies and redress for violation of environmental laws, and D. To enable the courts to monitor and exact compliance with orders and judgments in environmental cases. B. Salient features. Salient features of the new rules are: the threshold on locus standi has been liberalized. Citizen suits are encouraged but with safeguards against nuisance suits. SLAP. Environmental disputes are subject of mediation. Provisions have been made to minimize delays and ensure effective and judicious disposition of environmental cases by providing for continuous trial, disallowing the filing of certain deal-prone pleadings, prohibiting the issuance of TROs against government agencies' action to enforce environmental laws or prevent violations thereof, referral of scientific and technical issues to a panel of experts, and prescribing stay of judgments by appeal. A new aspect of the rules is the Writ of Calicon, which authorizes the court, where the violation or threatened violation results in destruction or damage of such magnitude as to impair and deprive the right of the people to a balanced and healthful ecology, to direct the respondent to immediately desist from undertaking the activities complained of and to take positive steps to preserve, rehabilitate, or restore the environment. The rules also provide for discovery measures, like inspection order and production order, and submission of memoranda in the form of a draft decision. The writ of continuing mandamus is also harnessed to monitor compliance with court judgments. The rules contain a provision on citizens' arrest and seizure of the items, tools and conveyances used in committing the offense, and the custody, preservation, and disposition thereof. The rules integrate the caveat that the judge shall be guided by the precautionary principle where full scientific certainty shall not be required of the party alleging environmental damage. The rules reflect the sentiment that people who suffer from infringements of environmental laws must not be impeded in pursuing their remedies in court. The rules strengthen the hand of government in enforcing environmental laws, embrace the latest and best practices in other jurisdictions to effectuate the vindication of environmental rights in our justice system, and provide innovations customized to our distinct needs. 08. Rules of Procedure for Environmental Cases, a Judicial Reform Initiative. With the issuance of the Rules of Procedure for Environmental Cases, the Supreme Court has fulfilled its constitutional duty to promulgate rules concerning the protection and enforcement of constitutional rights, for example, the right of the people to a balanced and healthful ecology, and providing a simplified and inexpensive procedure for the speedy disposition of environmental cases. By its landmark decisions in Oposa versus Factorin, which declared that the right to a balanced and healthful ecology belongs to a different category of rights, for it concerns nothing less than self-preservation and self-perpetuation, and Metropolitan Manila Development Authority versus Concerned Citizens of Manila Bay, which stressed that the cleaning and rehabilitation of Manila Bay and preserving its water quality to the ideal level can be compelled by mandamus. The Supreme Court has carved a niche for itself as an important dispenser of environmental justice. Chapter 2 Public Land Act, Commonwealth Act Number 141. A preliminary. 01. Governing Law. Commonwealth Act Number 141, otherwise known as the Public Land Act, was enacted on November 7, 1936. Its provisions apply to lands of the public domain, but timber and mineral lands are governed by special laws. The lands commonly called Seven Rire lands and those which, being privately owned, have reverted to or become the property of the Republic of the Philippines, are governed by the laws presently in force or which may hereafter be enacted. 02. Historical background. Act No. 926, the first Public Land Act, was passed in pursuance of the provisions of the Philippine Bill of 1902. The law governed the disposition of lands of the public domain. It prescribed rules and regulations for the homesteading, selling, and leasing of portions of the public domain of the Philippine Islands, and prescribed the terms and conditions to enable persons to perfect their titles to public lands in the islands. It also provided for the issuance of patents to certain native settlers upon public lands, for the establishment of town sites and sale of lots therein, for the completion of imperfect titles, and for the cancellation or confirmation of Spanish concessions and grants in the islands. Act No. 926 was superseded in 1919 by Act No. 2874, the Second Public Land Act. This new law was passed under the Jones Law. It was more comprehensive in scope but limited the exploitation of agricultural lands to Filipinos and Americans and citizens of other countries, which gave Filipinos the same privileges. After the passage of the 1935 Constitution, Commonwealth Act No. 141, the present Public Land Act, was enacted on November 7, 1936. Commonwealth Act No. 141 is essentially the same as Act No. 2874. 2 Grants of public lands are brought under the operation of the torrent system of registration pursuant to Section 103 of PD No. 1529, or the Property Registration Decree, formerly Section 122 of Act No. 496 or Land Registration Act. The instruments mentioned in Section 103 whereby public lands are alienated, granted, or conveyed are instruments transferring ownership, not documents of lease, transferring mere possession. The provision directs the issuance to the grantee of an owner's duplicate certificate. After due registration and issuance of the certificate of title, the land shall be deemed registered land to all intents and purposes under the Property Registration Decree. Public land patents when duly registered are veritable torrent titles subject to no encumbrances except those stated therein, plus those specified by the statute. They become private property which can no longer be the subject of subsequent disposition by the Director of Lands. 4. The Public Land Act, which compiled the then existing laws on lands of the public domain, remains to this day the existing general law governing the classification and disposition of lands of the public domain other than timber and mineral lands. 03. Policy considerations. The state shall ensure, for the benefit of the Filipino people, the full exploration and development as well as the judicious disposition, utilization, management, renewal and conservation of the country's forest, mineral, land, waters and other natural resources, consistent with the objective of making the exploration, development and utilization of such natural resources equitably accessible to the different segments of the present as well as future generations. The state shall likewise recognize and apply a true value system that takes into account social and environmental cost implications relative to the utilization, development, and conservation of our natural resources. The Department of Environment and Natural Resources, Department, shall be primarily responsible for the implementation of the foregoing policy. It shall be in charge of carrying out the state's constitutional mandate to control and supervise the exploration, development, utilization, and conservation of the country's natural resources. 04. Regalian Doctrine. All lands and other natural resources are owned by the state. Under Section 2, Article 12 of the Constitution, which embodies the Regalian Doctrine, all lands of the public domain belong to the state, the source of any asserted right to ownership of land. All lands not appearing to be clearly of private dominion presumptively belong to the state. Accordingly, public lands not shown to have been reclassified or released as alienable agricultural land or alienated to a private person by the state remain part of the inalienable public domain. 8. The Regalian Doctrine finds expression in Section 2, Article 12 of the Constitution on the National Economy and Patrimony, which provides: Section 2. All lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreements with Filipino citizens, or corporations or associations at least 60% of whose capital is owned by such citizens. Such agreements may be for a period not exceeding 25 years, renewable for not more than 25 years, and under such terms and conditions as may be provided by law. In cases of water rights for irrigation, water supply, fisheries, or industrial uses other than the development of water power, beneficial use may be the measure and limit of the grant. XXX. Except for agricultural lands, natural resources cannot be alienated. The exploration, development and utilization, (EDU), of natural resources shall be under the full control and supervision of the state. The state may directly undertake the exploitation and development by itself, or, it may allow participation by the private sector through co-production, joint venture, or production sharing agreements. The Regalian Doctrine reserves to the state all natural wealth that may be found in the bowels of the earth, even if the land where the discovery is made be private. Thus, once minerals are discovered in the land, whatever the use to which it is being devoted at the time, such use may be discontinued by the state to enable it to extract the minerals therein in the exercise of its sovereign prerogative. B. Organizational structure. 05. Department of Environment and Natural Resources. The Public Land Act provides that the Secretary of Environment and Natural Resources is the executive officer charged with carrying out the provisions of the Public Land Act, through the Director of Lands, who shall act under his immediate control. Subject to said control, the Director of Land shall have direct executive control of the survey, classification, lease, sale or any other form of concession or disposition and management of the lands of the public domain, and his decisions as to questions of fact shall be conclusive when approved by the Secretary of Environment and Natural Resources, in the absence of a showing that such decision was rendered in consequence of fraud, imposition, or mistake, other than error of judgment in estimating the value or effect of evidence, regardless of whatever or not it is consistent with the preponderance of the evidence, so long as there is some evidence upon which the finding in question could be made. It is understood of course that the decision of the Director of Lands may be annulled or reviewed in a direct proceeding and not collaterally, as when the issue involves a question of law or is based upon a misconstruction of the law, or when the conclusions drawn by the Secretary from the facts found are erroneous or not warranted by law. However, the jurisdiction of the Department over public lands does not negate the authority of courts of justice to resolve questions of possession, and their decisions stand in the meantime that the Department itself has not settled the respective rights of public land claimants. But once the Department has decided, particularly with the grant of a public land patent, for instance, and issuance of the corresponding certificate of title, its decision prevails. The DENR is the primary government instrumentality charged with the mandate of promulgating rules and regulations for the protection of the environment and conservation of natural resources, but it is not the only government instrumentality clothed with such authority. Municipal governments are clothed with authority to enact ordinances and issue such regulations as may be necessary to provide for the health, safety, comfort and convenience, maintain peace and order, improve public morals, promote the prosperity and general welfare of the municipality and its inhabitants, and ensure the protection of property in the municipality. A. Specific functions of the Department Secretary. Section 4, Chapter 1, Title 14 of the Revised Administrative Code of 1987 specifically vests in the Department the following powers and functions. Section 4. Powers and functions. The Department shall 4. Exercise supervision and control over forest lands, alienable and disposable public lands, mineral resources and, in the process of exercising such control, impose appropriate taxes, fees, charges, rentals and any such form of levy and collect such revenues for the exploration, development, utilization or gathering of such resources. 14. Promulgate rules, regulations and guidelines on the issuance of licenses, permits, concessions, lease agreements and such other privileges concerning the development, exploration and utilization of the country's marine, freshwater, and brackish water and overall aquatic resources of the country, and shall continue to oversee, supervise and police our natural resources, cancel or cause to cancel such privileges upon failure, non-compliance or violations of any regulation, order, and for all other causes which are in furtherance of the conservation of natural resources and supportive of the national interest. 15. Exercise exclusive jurisdiction on the management and disposition of all lands of the public domain and serve as the sole agency responsible for classification, subclassification, surveying and titling of lands in consultation with appropriate agencies. The department is mandated to accelerate cadastral and emancipation patent surveys, land use planning and public land titling. B. Specific functions of the LMB Director and Regional Officers. The administration and distribution of public lands is committed by law to the Director of Lands primarily, and ultimately, to the Department Secretary. 21 Under EO No. 192, the newly created Lands Management Bureau, LMB, has absorbed the functions and powers of the Bureau of Lands except those line functions and powers which were transferred to the regional field offices. The LMB is headed by a director and assisted by an assistant director who shall advise the department secretary on matters pertaining to rational land classification management and disposition, and shall have the following functions. A. Recommend policies and programs for the efficient and effective administration, surveys, management and disposition of alienable and disposable lands of the public domain and other lands outside the responsibilities of other government agencies, such as reclaimed areas and other areas not needed for or are not being utilized for the purposes for which they have been established. B. Advise the regional offices on the efficient and effective implementation of policies, programs and projects for more effective public lands management. C. Assist in the monitoring and evaluation of land surveys, management and disposition of lands to ensure efficiency and effectiveness thereof. D. Issue standards, guidelines, regulations and orders to enforce policies for the maximization of land use and development. E. Develop operating standards and procedures to enhance the Bureau's objectives and functions. F. Assist the Secretary as executive officer charged with carrying out the provisions of the Public Land Act, Commonwealth Act Number 141, as amended, who shall have direct executive control of the survey, classification, lease, sale or any other forms of concessions or disposition and management of the lands of the public domain. G. Perform other functions as may be assigned by the Secretary and or provided by law. The regional offices of the then Bureau of Forest Development, Bureau of Mines and Geosciences and Bureau of Lands in each of the 13 administrative regions are now integrated into the department. Wide Regional Environment and Natural Resources Office of the Department. A regional office is headed by a regional executive director who shall be assisted by 5 regional technical directors. C. Delegated functions under DEN Administrative Order No. 38, Series of 1990, various regulatory and administrative matters and delegated functions are defined. On land management, the Department Secretary approves, among other things, the appraisal of public lands and issues authority to conduct bidding covering agricultural land sales above 5 hectares and leases covering 100 hectares and above, approves transfer of public land applications or deeds of sale, mortgage of patented lands above 12 hectares, decides cases on appeal involving claims, conflicts over public lands, and signs patents for areas more than 5 hectares for sales and more than 10 hectares for homestead and free patents. The Regional Executive Director, RED, issues orders of bidding and signs contracts for cadastral and public land subdivision survey projects, issues investigation orders involving patented lots, decides claims and conflicts involving public lands, issues orders of execution, signs patents and reconstituted patents for areas up to 5 hectares for sales and 5 up to 10 hectares for homestead and free patent, and issues original revocable or provisional permits for alienable and disposable lands. The Regional Technical Director, RTD, verifies, approves and signs maps and plans for public land subdivision, cadastral and isolated surveys, approves survey plans for OLT and other agrarian reform projects, verifies and approves political boundary surveys, and issues survey orders for public land subdivision and cadastral survey covering land up to 500 hectares. The Provincial Environment and Natural Resources Officer, PENRO, issues certificates of land classification for areas over 50 hectares, approves appraisal of public lands and issues authority to conduct bidding on sales and leases for areas up to 1,000 square meter for commercial, industrial and residential purposes, approves appraisal of public lands and issues authority to conduct bidding covering leases below 5 hectares for agricultural purposes, issues orders of investigation involving claims and conflicts over unpatented lots, and signs patents and reconstituted patents for areas up to 5 hectares for homestead and free patent. The Community Environment and Natural Resources Officer, CENRO, issues survey orders to conduct isolated surveys, issues certificates of land classification for areas below 50 hectares, accepts public land applications and processes the same, conducts oral or sealed bidding for the sale or lease of public lands, and issues survey orders for the subdivision of cadastral lots for patented and unpatented lands. See Classification of Lands. 06. Classification of lands. Generally, government lands are classified in a number of ways. They may be, a. lands of the public domain, either alienable or inalienable, or, b. lands of the private domain, which refer to land belonging to and owned by the state as a private individual, without being devoted for public use, public service or the development of national wealth, similar to patrimonial properties of the state. Under the Civil Code, government lands can either be properties of the public dominion, or those intended for public use, such as roads, canals, rivers, torrents, ports and bridges constructed by the state, banks, shores, roadsteads, and others of similar character, or those which belong to the state, without being for public use, intended for some public service or for the development of the national wealth, or patrimonial properties of the state, that is, properties other than properties of the public dominion or former properties of the public-like dominion that are no longer intended for public use or for public service. A. Classification of lands of the public domain under the Constitution. Under the 1987 Constitution, lands of the public domain are classified into 4 categories. namely, a. agricultural, b. forest or timber, c. mineral lands, and d. national parks. Only agricultural lands, which may be further classified according to the uses or purposes to which they are destined, may be disposed of in accordance with law. Section 3, Article 12 of the Constitution provides, Section 3. Lands of the public domain are classified into agricultural, forest or timber, mineral lands, and national parks. Agricultural lands of the public domain may be further classified by law according to the uses to which they may be devoted. Alienable lands of the public domain shall be limited to agricultural lands. Private corporations or associations may not hold such alienable lands of the public domain except by lease, for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares in area. Citizens of the Philippines may lease not more than 500 hectares, or acquire not more than 12 hectares thereof by purchase, homestead or grant. The 1935 Constitution classified lands of the public domain into three groups, namely, agricultural, timber and mineral, and the term public agricultural lands has always been construed as referring to those lands that were neither timber nor mineral, and as including residential lands. In contrast, the 1973 Constitution classified lands of the public domain into agricultural, industrial, or commercial, residential, resettlement, mineral, timber or forest, and grazing lands, and such other classes as may be provided by law. The Public Land Act, as amended, governs lands of the public domain, but timber and mineral lands are governed by special laws. The administration and disposition of friar lands and those lands which, being privately owned, have reverted to or become the property of the state, are governed by laws presently in force. Under Section 6 of the Public Land Act, the prerogative of classifying or reclassifying lands of the public domain, that is, from forest or mineral to agricultural and vice versa, belongs to the executive branch of the government and not the court. Needless to stress, the onus to overturn, by incontrovertible evidence, the presumption that the land subject of an application for registration is alienable or disposable rests with the applicant. b. Classification of lands under the Public Land Act for purposes of the administration and disposition of alienable or disposable public lands. The President, upon recommendation of the Secretary of Environment and Natural Resources, shall from time to time declare what lands are open to disposition or concession under the Act. 29 Section 6 of the Public Land Act classifies lands of the public domain into a. alienable or disposable, b. timber, and c. mineral lands. The President may at any time and in a like manner transfer such lands from one class to another, for the purposes of their administration and disposition. c. Classification of public lands open to disposition for purposes of their administration and disposition. Lands of the public domain which are alienable or open to disposition may be further classified according to the use or purposes to which such lands are destined, as follows: a. agricultural, b. residential, commercial, industrial, or for similar productive purposes, c. educational, charitable, or other similar purposes, d. reservations for town sites and for public and quasi-public uses. The President, upon recommendation by the Secretary of Environment and Natural Resources, shall from time to time make the classifications provided for in this section, and may, at any time and in a similar manner, transfer lands from one class to another. 3 degrees Section 9 of Commonwealth Act Number 141 provides that the alienable or disposable public land shall be classified, according to the use or purposes to which they are destined, into agricultural, residential, commercial, industrial, etc., lands. At first blush it would seem that under this classification residential land is different from agricultural land. The difference, however, is more apparent than real. Public agricultural lands, as that phrase is used in the Constitution, means alienable lands of the public domain, and therefore this phrase is equivalent to the lands classified by Commonwealth Act Number 141 as alienable or disposable. The classification provided in Section 9 is only for purposes of administration and disposition, according to the purposes to which said lands are especially adapted. But notwithstanding this classification, all of said lands are essentially agricultural public lands, because only agricultural public lands are subject to alienation or disposition under Section 2, Article 12 of the Constitution. From the foregoing classification, public agricultural land may be defined as those alienable portions of the public domain which are neither timber nor mineral lands. Thus, the term includes residential, commercial, and industrial lands for the reason that these lands are neither timber nor mineral lands. 07. Classification of lands and executive prerogative. Before the government could alienate or dispose of lands of the public domain, the President must first officially classify these lands as alienable or disposable, and then declare them open to disposition or concession. There must be no law reserving these lands for public or quasi-public uses. The classification is a prerogative of the executive department and not the courts. Section 6 of Commonwealth Act Number 141 provides that the classification or reclassification of public lands into alienable or disposable, mineral or forest lands is a prerogative of the executive department of the government and not of the courts. As stressed in Director of Lands v. Court of Appeals in Bisnar. It bears emphasizing that a positive act of the government is needed to declassify land which is classified as forest and to convert it into alienable or disposable land for agricultural or other purposes. Republic v. Animas, 56 Supreme Court Reports annotated 499. Unless and until the land classified as forest is released in an official proclamation to that effect so that it may form part of the disposable agricultural lands of the public domain, the rules on confirmation of imperfect title do not apply. Amanatgi v. Director of Forestry, 126 Supreme Court Reports annotated 69, Director of Lands v. Court of Appeals, 129 Supreme Court Reports annotated 689, Director of Lands v. Court of Appeals, 133 Supreme Court Reports annotated 701, Republic v. Court of Appeals, 148 Supreme Court Reports annotated 480, Vallarta v. Intermediate Appellate Court, 151 Supreme Court Reports annotated 679. 08. Public lands and government land distinguished. In Montano v. Insular Government, 36 it was held that the phrase public lands is equivalent to public domain, and does not by any means include all lands of government ownership, but only so much of said lands as are thrown open to private appropriation and settlement by homestead and other like general laws. Accordingly, government land and public land are not synonymous terms. The first includes not only the second, but also other lands of the government already reserved or devoted to public use or subject to private right. In other words, the government owns real estate which is part of the public lands and other real estate which is not a part thereof. D. Modes of disposition. 09. No public land can be acquired except by a grant from the state. No public land can be acquired by private persons without any grant, express or implied, from the government. In other words, it is indispensable that there be a showing of a title from the state. This may come in the form of a homestead, sales or free patent or grant. One claiming private rights must prove that he has complied with the Public Land Act, which prescribes the substantive as well as the procedural requirements for acquisition of public lands. 10. Only alienable and disposable, A and E, lands may be the subject of disposition. Only those lands shall be declared open to disposition or concession which have been officially delimited and classified and, when practicable, surveyed, and which have not been reserved for public or quasi-public uses, nor appropriated by the government, nor in any manner become private property, nor those on which a private right authorized and recognized by the Act or any valid law may be claimed, or which, having been reserved or appropriated, have ceased to be so. In the absence of such classification, the land remains as unclassified land until it is released therefrom and rendered open to disposition. In Mengido v. Republic, 41 it was held that unless public land is shown to have been reclassified or alienated to a private person by the state, it remains part of the inalienable public domain. Indeed, occupation thereof in the concept of owner, no matter how long, cannot ripen into ownership and be registered as title. Land remains unclassified land until it is released therefrom and rendered open to disposition. Adherence to the Regalian Doctrine subjects all agricultural, timber, and mineral lands to the dominion of the state. The conversion of property into a fish pond by the applicants, or the alleged titling of properties around it, does not automatically render the property as alienable and disposable. Applicants' remedy lies in the release of the property from its present classification. 11. Specific modes of disposition. Public lands suitable for agricultural purposes can be disposed of only as follows: a. For homestead settlement, b. By sale, by lease, and by confirmation of imperfect or incomplete titles, 1. By judicial legalization, 2. By administrative legalization. Free Patent 45. The words alienation, disposition, or concession, as used in the Public Land Act means any of the methods authorized by the Act for the acquisition, lease, use, or benefit of the lands of the public domain other than timber or mineral lands. Each mode of disposition is appropriately covered by separate chapters of the Public Land Act because there are specific requirements and application procedure for every mode. 47. A. For homestead settlement. Chapter 4, Homesteads, of the Public Land Act governs the disposition of alienable public lands through homestead. The law provides that any citizen of the Philippines over the age of 18 years, or the head of a family, may enter a homestead of not exceeding 12 hectares 48 of agricultural land of the public domain. The applicant must have cultivated and improved at least 1/5 of the land continuously since the approval of the application and resided for at least 1 year in the municipality in which the land is located, or in a municipality adjacent to the same, and then, upon payment of the required fee, he shall be entitled to a patent. 49.1. Effect of compliance with legal requirements. When a homesteader has complied with all the terms and conditions which entitle him to a patent for a particular tract of public land, he acquires a vested interest therein, and is to be regarded as the equitable owner thereof. The execution and delivery of the patent, after the right to a particular parcel of land has become complete, are the mere ministerial acts of the officer charged with that duty. Even without a patent, a perfected homestead is a property right in the fullest sense, unaffected by the fact that the paramount title to the land is still in the government. Such land may be conveyed or inherited. No subsequent law can deprive him of that vested right. In Mizina v. Sanza, the Supreme Court, citing Susi v. Rizan, held that once a homestead applicant has complied with all the conditions essential to a government grant, he acquires not only a right to a grant, but a grant of the government. Thus, see where all the necessary requirements for a grant by the government are complied with through actual physical possession openly, continuously, and publicly, with a right to a certificate of title to said land under the provisions of Chapter 7 of Act Number 2874, amending Act Number 926. Carried over as Chapter 8 of Commonwealth Act Number 141, the possessor is deemed to have already acquired by operation of law not only a right to a grant, but a grant of the government, for it is not necessary that a certificate of title be issued in order that said grant may be sanctioned by the courts, an application therefore being sufficient under the provisions of Section 47 of Act Number 2874, reproduced as Section 50. Commonwealth Act Number 141. As explained in Lahiri v. Diang Irang, where disposable public land is granted by the government by virtue of a public land patent, like homestead, sales or free patent, the patent is recorded and the corresponding certificate of title is issued to the grantee. Thereafter, the land is automatically brought within the operation of the property registration decree, entitled to all the safeguards of a veritable torrens title. In other words, upon expiration of 1 year from its issuance, the certificate of title shall become irrevocable and indefeasible like a certificate issued in a registration proceeding. In Pajomeo v. Minapon, it was held that once a homestead patent granted in accordance with the Public Land Act is registered pursuant to Section 122 of Act Number 496, Section 103 of PD Number 1529, the certificate of title issued by virtue of said patent has the force and effect of a torrens title issued through judicial registration proceedings. This principle is applicable to certificates of title issued by virtue of other land patents under the Public Land Act. 2. Transfer of rights. If at any time after the approval of the application and before the patent is issued, the applicant shall prove to the satisfaction of the Director of Lands that he has complied with all the requirements of the law, but cannot continue with his homestead, through no fault of his own, and there is a bona fide purchaser for the rights and improvements of the applicant on the land, and that the conveyance is not made for purposes of speculation, then the applicant, with the previous approval of the Director of Lands, may transfer his rights to the land and improvements to any person legally qualified to apply for a homestead, and immediately after such transfer, the purchaser shall file the homestead application to the land so acquired and shall succeed the original homesteader in his rights and obligations beginning with the date of the approval of said application of the purchaser. Any person who has so transferred his rights may not again apply for a new homestead. Every transfer made without the previous approval of the Director of Land shall be null and void and shall result in the cancellation of the entry and the refusal of the patent. 3. Registration court cannot be divested of jurisdiction by subsequent issuance of a homestead patent over the same land subject of registration. A land registration court which has validly acquired jurisdiction over a parcel of land for registration of title cannot be divested of said jurisdiction by a subsequent administrative act consisting in the issuance by the Director of Lands of a homestead patent covering the same parcel of land. As held in De Los Angeles v. Santos, the Director of Lands jurisdiction, administrative supervision and executive control extend only over lands of the public domain and not to lands already of private ownership. Accordingly, a homestead patent issued by him over land not of the public domain is a nullity, devoid of force and effect against the owner. b. Sale of public agricultural lands. Alienable lands of the public domain may be disposed of through sale or lease under specific provisions of the Public Land Act or under special laws. The acquisition of public agricultural lands by purchase is governed by Chapter 5, Sale, of the Public Land Act. Any citizen of the Philippines of lawful age or the head of a family may purchase any tract of public agricultural land not to exceed 12 hectares which shall be sold through sealed bidding. The land shall be awarded to the highest bidder, but the applicant may equal the highest bid. The purchase price may be paid in full upon the making of the award or in not more than 10 equal annual installments from the date of the award. It is required that the purchaser shall have not less than 1/5 of the land cultivated within 5 years from the date of the award, and before any patent is issued, he must show actual occupancy, cultivation, and improvement of at least 1/5 of the land until the date of final payment. After the cultivation of the land has begun, the purchaser, with the approval of the Secretary of Environment and Natural Resources, may convey or encumber his rights to any person, corporation, or association legally qualified under the Act to purchase agricultural public lands, provided such conveyance or encumbrance does not affect any right or interest of the government in the land, and provided, further, that the transferee is not delinquent in the payment of any installment due and payable. Any sale and encumbrance made without the previous approval of the Secretary shall be null and void and shall produce the effect of annulling the acquisition and reverting the property and all rights to the state, and all payments on the purchase price theretofore made to the government shall be forfeited. After the sale has been approved, the vendor shall not lose his right to acquire agricultural public lands under the provisions of the Act, provided he has the necessary qualifications. C. Lease. Any citizen of lawful age of the Philippines, and any corporation or association of which at least 60% of the capital stock or of any interest in said capital stock belongs wholly to citizens of the Philippines, may lease any tract of agricultural public land available for lease under Chapter 6, Lease, of the Act. 6 degrees pursuant to Section 3, Article 12 of the present Constitution. Private corporations may lease alienable lands of the public domain for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares. Citizens of the Philippines may lease not more than 500 hectares, or acquire not more than 12 hectares thereof by purchase, homestead, or grant. It shall be an inherent and essential condition of the lease that the lessee shall have not less than 1/3 of the land broken and cultivated within 5 years after the date of the approval of the lease. However, in case the land leased is to be devoted to pasture, it shall be sufficient compliance with this condition if the lessee shall graze on the land as many heads of cattle as will occupy at least 1/2 of the entire area at the rate of 1 head per hectare. D. Confirmation of imperfect or incomplete title, judicial legalization. The confirmation of imperfect or incomplete titles may be done in 2 ways, a. Judicial legalization or judicial confirmation of imperfect or incomplete titles under Chapter 8 of the Public Land Act, and b. Administrative legalization or free patents under Chapter 7 of the same Act. Section 48b and c. of the Public Land Act, as amended, reads, Section 48. The following described citizens of the Philippines, occupying lands of the public domain or claiming to own any such lands or an interest therein, but whose titles have not been perfected or completed, may apply to the regional trial court of the province where the land is located for confirmation of their claims and the issuance of a certificate of title therefor, under the property registration decree, to wit. 30. b. Those who by themselves or through their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain, under a bona fide claim of acquisition or ownership, since June 12, 1945, except when prevented by war or force majeure. These shall be conclusively presumed to have performed all the conditions essential to a government grant and shall be entitled to a certificate of title under the provisions of this chapter. As amended by PD number 1073, c. Members of the national cultural minorities who by themselves or through their predecessors sign interest have been in open, continuous, exclusive and notorious possession and occupation of lands of the public domain suitable to agriculture, whether disposable or not, under a bona fide claim of ownership for at least 30 years shall be entitled to the rights granted in subsection b. hereof. As amended by RA number 3872. Section 48C, as amended by PD number 1073. Shall now apply only to alienable and disposable lands. 1. Ownership based on adverse possession. As a rule, no title or right to, or equity in, any lands of the public domain may be acquired by prescription or by adverse possession or occupancy except as expressly provided by law. However, the Public Land Act, Commonwealth Act Number 141, recognizes the concept of ownership under the civil law. This ownership is based on adverse possession and the right of acquisition is governed by Chapter 8 on judicial confirmation of imperfect or incomplete titles. The applicant must prove that, a. the land is alienable public land, and b. his possession and occupation has been exercised in the manner and for the period prescribed by law, or since June 12, 1945.63 registration under the Act presumes that the land was originally public agricultural land, but because of adverse possession since June 12, 1945, the land has become private. 2. Period of possession pursuant to RA No. 1942 dated June 22, 1957. The required possession was at least 30 years immediately preceding the filing of the application. However, RA No. 1942 was repealed by PD No. 1073 on January 25, 1977. PD No. 1073 now requires possession since June 12, 1945, or earlier. As clarified in Latin Defi Incorporated vs. Republic, only applications for registration filed prior to January 25, 1977 may invoke RA No. 1942. PD No. 1073 also, a. extended the period for the filing of applications for judicial confirmation of imperfect and incomplete titles to December 31, 1987, b. limited the area of the land applied for to 144 hectares, c. repealed Section 48b on judicial confirmation of incomplete titles to public land based on unperfected Spanish grants, and d. amended Sections 48b and c. in the sense that these provisions shall apply only to alienable and disposable, A and E, lands of the public domain which have been in open, continuous, exclusive and notorious possession and occupation by the applicant himself or through his predecessors in interest, under a bona fide claim of acquisition of ownership, since June 12, 1945. As held in Republic vs. Doidel, the law, as presently phrased, requires that possession of lands of the public domain must be from June 12, 1945 or earlier, for the same to be acquired through judicial confirmation of imperfect title. It should be underscored, however, that a court's jurisdiction depends on the law existing at the time an action is filed and a law continues to be in force with regard to all rights which accrued prior to the amendment thereof. 3. RA No. 9176 has extended period of filing to December 31, 2020 on November 13, 2002. RA No. 9176 was enacted, a. extending the period to file an application for judicial confirmation of imperfect or incomplete titles to December 31, 2020, b. further limiting the area applied for to 12 hectares, and c. providing that all pending applications filed before the effectivity of the Amendatory Act shall be treated as having been filed in accordance with the provisions thereof. 4. Requisites for availment of Chapter 8. Considering the present state of the law, the following conditions must concur in order that the benefits of Chapter 8 of the Public Land Act on notices and other legal requirements, and forward his recommendation to the Provincial Environment and Natural Resources Office, PENRO, who shall have 5 days to approve or disapprove the patent. In case of approval, patent shall be issued. In case of conflicting claims among different claimants, the parties may seek the proper judicial remedies. The restrictions regarding encumbrances, conveyances, transfers or dispositions imposed in Sections 118, 119, 121, 122, and 123 of Chapter 13, Title V of Commonwealth Act Number 141, as amended, shall not apply to patents issued under the Act. G. Classification and disposition of lands for residential, commercial, or industrial purposes under Chapter 9, Classification and concession of public lands suitable for residence, commerce, and industry, Title III, of the Public Land Act. It is provided that any tract of land of the public domain which, being neither timber nor mineral land, is intended to be used for residential purposes or for commercial, industrial, or other productive purposes other than agricultural, and is open to disposition or concession, shall be disposed of under the provisions of said chapter and not otherwise. Section 59 classifies the lands disposable under Title III as follows. A. Lands reclaimed by the government by dredging, filling, or other means. B. Foreshore. C. Marshy lands or lands covered with water bordering upon the shores or banks of navigable lakes or rivers. D. Lands not included in any of the foregoing classes. 1. Modes of disposition. Sale or lease. The lands may be leased or sold, as the case may be, to any person, corporation, or association authorized to purchase or lease public lands for agricultural purposes. 69 Under the Constitution, private corporations may only lease alienable lands of the public domain for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares in area. Citizens of the Philippines may lease not more than 500 hectares, or acquire not more than 12 hectares thereof by purchase, homestead, or grant. The lands comprised in classes A, B, and C of Section 59 shall be disposed of to private parties by lease only and not otherwise, as soon as the President, upon recommendation by the Secretary of Environment and Natural Resource, shall declare that the same are not necessary for the public service and are open to disposition. The lands included in Class D may be disposed of by sale or lease under the provisions of the Act. The sale of the lands comprised in Class D of Section 59 shall, among others, comprise the following conditions. A. The purchaser shall make improvements of a permanent character appropriate for the purpose for which the land is purchased, shall commence work thereon within 6 months from the receipt of the order of award, and shall complete the construction of said improvements within 18 months from the date of such award. Otherwise, the Secretary of Environment and Natural Resources may rescind the contract. B. The purchase price shall be paid in cash or in equal annual installments, not to exceed 10. The contract of sale may contain other conditions not inconsistent with the provisions of this Act. As amended by RA No. 293, however, marshy lands and lands underwater bordering on shores or banks of navigable lakes or rivers which are covered by subsisting leases or leases which may hereafter be granted and are already improved and have been utilized for farming, fish pond, or similar purposes for at least 5 years from the date of the contract of lease, may be sold to the lessees thereof under Chapter 5 of the Act as soon as the President, upon recommendation of the Secretary, shall declare that the same are not necessary for the public service. A foreshore land is that strip of land that lies between the high and low water marks and that is alternately wet and dry according to the flow of the tide. Foreshore lands, submerged areas and reclaimed lands are inalienable unless converted by law into alienable and disposable lands of the public domain. The shores and the lands reclaimed from the sea, while they continue to be devoted to public uses and no grant whatever has been made of any portion of them to private persons, remain a part of the public domain and are for public uses, and, until they are converted into patrimonial property of the state, such lands, thrown up by the action of the sea, and the shores adjacent thereto, are not susceptible of prescription, inasmuch as, being dedicated to the public uses, they are not subject of commerce among men, in accordance with the provision of the Civil Code. 175 However, reclaimed lands may be the subject of lease under the conditions provided by law. 411 S.O. 192, Conditions of the Lease. Section 64 provides that the lease shall contain, among other conditions, the following. D. The lessee shall construct permanent improvements appropriate for the purpose for which the lease is granted, shall commence the construction thereof within 6 months from the date of the award of the right to lease the land, and shall complete the said construction within 18 months from said date. E. At the expiration of the lease or of any extension of the same, all improvements made by the lessee, his heirs, executors, administrators, successors, or assigned shall become the property of the government. In Ludu and Lunecorp. Versus Asner Brothers Realty Co. 176 it was held that the failure to comply with the condition for the construction of improvements does not automatically give rise to the rescission of the lease contract. This is clear from the last paragraph of Section 64 of the Public Lands Act, which states, "The violation of one or any of the conditions specified in the contract shall give rise to the rescission of said contract." The Secretary of Environment and Natural Resources may, however, subject to such conditions as he may prescribe, waive the rescission arising from a violation of the conditions of subsection D, or extend the time within which the construction of the improvements shall be commenced and completed. Emphasis supplied. Section 68 provides that the Secretary of Environment and Natural Resources may grant qualified persons temporary permission, upon payment of a reasonable charge, for the use of any portion of the lands covered by Chapter 9 for any lawful private purpose, subject to revocation at any time when, in his judgment, the public interest shall require it. Thus, even granting that petitioner is a legitimate holder of a temporary permit to occupy the land, said permit being merely temporary, may be revoked at any time by the Secretary. Where land has been the subject of a foreshore lease application, the fact that the land has subsequently ceased to be a foreshore because the land has been converted into a commercial or industrial land shall not result in the revocation of the lease. Since the said land was a foreshore land at the time the application was filed, the right to lease the same should still be awarded to the applicant. 178 hours. Lands for residential, commercial or industrial purposes shall be disposed of through oral bidding, exception direct sale. Section 67 of Commonwealth Act Number 141 provides the procedure for the disposition of lands of the public domain which are open to disposition or concession and intended to be used for residential, commercial, industrial or other productive purposes other than agricultural, to wit, Section 67. The lease or sale shall be made through oral bidding, and adjudication shall be made to the highest bidder. However, where an applicant has made improvements on the land by virtue of a permit issued to him by competent authority, the sale or lease shall be made by sealed bidding as prescribed in Section 26 of this Act, the provisions of which shall be applied wherever applicable. If all or part of the lots remain unleased or unsold, the Director of Land shall from time to time announce in the Official Gazette or in any other newspapers of general circulation, the lease or sale of those lots, if necessary. With the enactment of RA No. 730 on June 18, 1952, however, an exception to the foregoing procedure was created by authorizing disposition of lands of the public domain by private sale, instead of bidding, provided that, 1. The applicant has in his favor the conditions specified therein, and, 2. The area applied for is not more than 1,000 square meters. The pertinent provision of RA No. 730 provides, Section 1. Notwithstanding the provisions of Sections 61 and 67 of Commonwealth Act No. 140 own, as amended by Republic Act No. 293, any Filipino citizen of legal age who is not the owner of a home lot in the municipality or city in which he resides and who has in good faith established his residence on a parcel of the public land of the Republic of the Philippines which is not needed for the public service, shall be given preference to purchase at a private sale of which reasonable notice shall be given to him not more than 1,000 square meters at a price to be fixed by the Director of Lands with the approval of the Secretary of Agriculture and Natural Resources. It shall be an essential condition of this sale that the occupant has constructed his house on the land and actually resided therein. 10% of the purchase price shall be paid upon the approval of the sale and the balance may be paid in full, or in 10 equal annual installments. To be qualified, the applicant must, a. be a Filipino citizen of legal age, b. not the owner of a home lot in the municipality or city in which he resides, c. have established in good faith his residence on a parcel of public land which is not needed for public service, and d. have constructed his house and actually resided therein. If he complies with these conditions, he shall be given preference to purchase at a private sale not more than 1,000 square meters of land at a price to be fixed by the Director of Lands. RA number 730 merely provides an exception to sections 61 and 67 of Commonwealth Act Number 141. In short, the law authorizes a sale by private sale, as an exception to the general rule that it should be by bidding, provided the area applied for does not exceed 1,000 square meters, and the applicant has in his favor the conditions specified for in Section 1 thereof. Hence, if the area applied for is in excess of 1,000 square meters, the sale must be done only through bidding. 179 Section 1 of RA number 730 gives a qualified applicant preference to purchase alienable public land suitable for residential purposes. The pendency of a protest does not justify the disposition of the land through any other mode, like public bidding, since the law directs that the land be the subject of a private sale through a miscellaneous sales application. Sale of lands within military reservations pursuant to RA number 274, 181 lands within military reservations, when declared by the President is no longer needed for military purposes, may be subdivided by the Director of Lands, and thereafter sold to persons qualified to acquire agricultural public lands under the Public Land Act, with priority given to bona fide occupants and then to war veterans. The area of each lot shall be determined by the Director of Lands according to the nature of the land, the number of prospective applicants, and the purpose for which it will be utilized. Concession of lands for educational, charitable and other similar uses under Chapter 10. Concession of lands for educational, charitable, and other similar purposes, Title 4, of the Public Land Act, it is provided that whenever any province, municipality, or other branch or subdivision of the government shall need any portion of the land of the public domain open to concession for educational, charitable, or other similar purposes, the President, upon recommendation by the Secretary of Environment and Natural Resources, may execute contracts in favor of the same, in the form of donation, sale, lease, exchange, or any other form, under terms and conditions to be inserted in the contract, but land so granted shall in no case be encumbered or alienated, except when the public service requires their being leased or exchanged, with the approval of the President, for other lands belonging to private parties, or if the Congress disposes otherwise. 182 Any tract of public land of the class covered by Title 4 may be sold or leased for the purpose of founding a cemetery, church, college, school, university, or other institutions for educational, charitable or philanthropical purposes or scientific research, the area to be such as may actually and reasonably be necessary to carry out such purpose. The sale or lease shall be made subject to the same conditions as required for the sale and lease of agricultural public land, but the Secretary of Environment and Natural Resources may waive the conditions requiring cultivation. The Secretary, if he sees fit, may order the sale to be made without public auction, at a price to be fixed by said Secretary, or the lease to be granted without auction, at a rental to be fixed by him. In either case, it shall be a condition that the purchaser or lessee or their successors or assigns shall not sell, transfer, encumber or lease the land for the purposes of speculation or use it for any purpose other than that contemplated in the application, and that the violation of this condition shall give rise to the immediate rescission of the sale or lease, as the case may be, and to the forfeiture to the government of all existing improvements. 188 Reservations. Townsite reservations, under Chapter 11 Townsite reservations of the Public Land Act, whenever it shall be considered to be in the public interest to found a new town, the Secretary of Environment and Natural Resources shall direct the Director of Lands to have a survey made of the exterior boundaries of the site on which such town is to be established, and upon the completion of the survey he shall send the same to said Secretary, with his recommendations. The Secretary, if he approves the recommendations of the Director of Lands, shall submit the matter to the President to the end that the latter may issue a proclamation reserving the land surveyed, or such part thereof as he may deem proper, as a town site, and a certified copy of such proclamation shall be sent to the Director of Lands and another to the Register of Deeds of the province in which the surveyed land lies. 185 It shall then be the duty of the Director of Lands, after having recorded the proclamation of the President, and the survey accompanying the same, and having completed the legal proceedings prescribed in Chapter 13 of the Act, to direct a subdivision of the site. 2. Reservations for public and semi-public purposes. Chapter 12 Reservations for public and semi-public purposes of the Act governs the establishment of reservations for public and semi-public purposes. Upon the recommendation of the Secretary of Environment and Natural Resources, the President may designate by proclamation any tract or tracts of land of the public domain as reservations for the use of the Republic of the Philippines or of any of its branches, or of the inhabitants thereof, in accordance with regulations prescribed for this purpose, or for quasi-public uses or purposes when the public interest requires it. A certified copy of every proclamation of the President issued under the provisions of this title shall be forwarded to the Director of Lands for record in his office, and a copy of this record shall be forwarded to the Register of Deeds of the province or city where the land lies. Upon receipt of such certified copy, the Director of Land shall order the immediate survey of the proposed reservation if the land has not yet been surveyed, and as soon as the plat has been completed, he shall proceed in accordance with the next following section. 3. Provisions common to reservations. The tract or tracts of land reserved under the provisions of Section 83 shall be non-alienable and shall not be subject to occupation, entry, sale, lease, or other disposition until again declared alienable under the provisions of this Act or by proclamation of the President. If all the lands included in the proclamation of the President are not registered under the Land Registration Act or Property Registration Decree, the Solicitor General, upon recommendation of the Department Secretary, shall proceed in accordance with the provision of Section 53 of the Act, which is akin to a compulsory judicial cadastral proceeding for the settlement and adjudication of title to lands. 12. Special patents. As a matter of ordinary land registration practice, a special patent is a patent to grant, cede, and convey full ownership of alienable and disposable lands formerly covered by a reservation or lands of the public domain, and is issued upon the promulgation of a special law or act of Congress or by the Secretary of Environment and Natural Resources as authorized by an executive order of the President. What is important in the definition of special patent is the grant by law of a property of the Republic for the full ownership of the grantee, while the classification of the land is not at all decisive in such description, since the special law or act of Congress or the executive order may classify the subject land differently. Thus the Department of Environment and Natural Resources DENR, through the Reservation and Special Land Grants section of the Lands Management Division, is tasked to issue special patents in favor of government agencies pursuant to special laws, proclamations, and executive orders XXX. An example of special patent is that issued by the President on January 19, 1988 to the Public Estates Authority, now Philippine Reclamation Authority, under PD number 1085, over 3 reclaimed islands known as the Freedom Islands located in the Manila Bay, and pursuant to which the Register of Deeds issued TCT Nos. 7309, 7311 and 7312 in the name of P. Registration of patents and issuance of certificates of title. 13. Registration of patent is the operative act to convey the land. Once a public land is alienated, granted or conveyed by the government, the same shall be brought forthwith under the operation of the property registration decree. It is the duty of the issuing agency of the government to cause the same to be filed and registered with the Register of Deeds, whereupon an owner's duplicate certificate of title shall be issued to the patentee or grantee. The patent or grant shall not take effect as a conveyance or bind the land but shall operate only as a contract between the government and the grantee. It is the act of registration that conveys or affects the land, and binds third persons. A certificate of title issued pursuant to a patent indefeasible. The torrent system aims to obviate possible conflicts of title by giving the public the right to rely upon the face of the torrent certificate and to dispense, as a rule, with the necessity of inquiring further, on the part of the registered owner. The system gives him complete peace of mind that he would be secured in his ownership as long as he has not voluntarily disposed of any right over the covered land. After due registration and issuance of the certificate of title, the land shall be deemed registered land and brought under the operation of the torrent system of registration. Public land patents when duly registered are veritable torrent titles subject to no encumbrance except those stated therein, plus those specified by the statute. They become private property which can no longer be the subject of disposition by the Director of Lands under the Public Land Act. 194. A public land patent when registered in the corresponding registry of deeds is a veritable torrent title and becomes as indefeasible as a torrent title upon the expiration of 1 year from the date of its issuance. 195. It becomes incontrovertible upon the expiration of 1 year from the date of the order for issuance of the patent. Hence, prescription cannot operate against the registered owner. B. Date of issuance of patent corresponds to the issuance of the decree in ordinary registration cases. There is no specific provision in the Public Land Act, Commonwealth Act Number 141, as amended, or the Land Registration Act Number 496, now Property Registration Decree PD number 1529, fixing the 1 year period within which the public land patent is open to review on the ground of actual fraud as Section 32 of the Property Registration Decree. It was held, however, that the date of issuance of the patent corresponds to the date of the issuance of the decree in ordinary registration cases because the decree finally awards the land applied for registration to the party entitled to it, and the patent issued by the Director of Lands equally and finally grants, awards, and conveys the land applied for to the applicant. After 1 year from the issuance of the corresponding patent, the same is no longer open to review on the ground of actual fraud, and a protest against its issuance no longer lies. C. Title cannot be defeated by adverse possession, nor subject to collateral attack. Once a title is registered, as a consequence either of judicial or administrative proceedings, the owner may rest secure, without the necessity of waiting in the portals of the court sitting in the Mirador de su casa to avoid the possibility of losing his land. 199. The certificate of title cannot be defeated by adverse, open and notorious possession. Neither can it be defeated by prescription. 200. In fact, by express provision of Section 48, PD number 1529, a certificate of title cannot be collaterally attacked. F. Prohibited alienations. 14. Prohibition against alienation of lands acquired under the Homestead and Free Patent provisions quoted below are relevant sections of the Public Land Act on prohibited alienation of public lands. Section 118. except in favor of the government or any of its branches, units or institutions, or illegally constituted banking corporations. Lands acquired under free patent or homestead provisions shall not be subject to encumbrance or alienation from the date of the approval of the application and for a term of 5 years from and after the date of issuance of the patent or grant, nor shall they become liable to the satisfaction of any debt contracted prior to the expiration of said period, but the improvements or crops on the land may be mortgaged or pledged to qualified persons, associations, or corporations. No alienation, transfer, or conveyance of any homestead after 5 years and before 25 years after issuance of title shall be valid without the approval of the Secretary of Agriculture and Natural Resources, which approval shall not be denied except on constitutional and legal grounds. As amended by Commonwealth Act Number 456, approved June 8, 1939. Section 121. Except with the consent of the grantee and the approval of the Secretary of Agriculture and Natural Resources, and solely for educational, religious, or charitable purposes or for right-of-way, no corporation, association, or partnership may acquire or have any right, title, interest, or property right whatsoever to any land granted under the free patent, homestead, or individual sale provisions of this Act or to any permanent improvement on such land. As amended by Commonwealth Act Number 615, approved May 5, 1941, Section 122. No land originally acquired in any manner under the provisions of this Act, nor any permanent improvement on such land, shall be encumbered, alienated or transferred, except to persons, corporations, association, or partnerships who may acquire lands of the public domain under this Act or to corporations organized in the Philippines authorized therefore by their charters. Except in cases of hereditary successions, no land or any portion thereof originally acquired under the free patent, homestead, or individual sale provisions of this Act, or any permanent improvement on such land, shall be transferred or assigned to any individual, nor shall such land or any permanent improvement thereon be leased to such individual, when the area of said land, added to that of his own, shall exceed 144 hectares. Any transfer, assignment, or lease made in violation hereto shall be null and void. As amended by Commonwealth Act Number 615, id. Section 124. Any acquisition, conveyance, alienation, transfer, or other contract made or executed in violation of any of the provisions of sections 118, 120, 120-1, 122, and 123 of this Act shall be unlawful and null and void from its execution and shall produce the effect of annulling and cancelling the grant, title, patent, or permit originally issued, recognized or confirmed, actually or presumptively, and cause the reversion of the property and its improvements to the state. By express provision of Section 118 of the Public Land Act, and in conformity with the policy of the law, any transfer or alienation of a free patent or homestead within 5 years from the issuance of the patent is proscribed. Such transfer nullifies said alienation and constitutes a cause for the reversion of the property to the state. A. Policy of the law. The prohibition has the avowed purpose of giving the homesteader or patentee every chance to preserve for himself and his family the land that the state had gratuitously given him as a reward for his labor in cleaning and cultivating it. As fully explained in Tainio v. Francis, the legislative policy or intent is to conserve the land which a grantee has acquired under the Public Land Act, for him and his heirs, and, as stated in Baniga v. Bugas, to give the patentee a place where to live with his family so he may become a happy citizen and useful member of our society. The legislative policy is so strong and consistent that the original period of 5 years from the issuance of the patent, within which period conveyance or sale thereof by the homesteader or his heirs was prohibited 205 is now extended to 25 years if no approval of the Secretary of Environment and Natural Resources is secured. Provision has also been inserted authorizing the repurchase of the homestead when properly sold by the homesteader within 5 years from the date of the sale. This legislative intent and policy is also sought to be carried out in Section 20 of the Public Land Act, as may be seen from the fact that transfer of homestead rights from a homesteader can only be justified upon proof satisfactory to the Director of Lands that the homesteader cannot continue with his homestead through no fault of his own. This is not the only requirement. A previous permission of the Secretary of Environment and Natural Resources should first be obtained, as it is also expressly provided that any transfer made without such previous approval is null and void and shall result in the cancellation of the entry and the refusal of the patent. B. Prohibition starts from date of approval up to 5th year from issuance of patent as held in Sala v. Court of First Instance of Negros Oriental. The prohibition to alienate commences to run from the date the application is approved, which may be a date earlier than the date of issuance of the patent. The period of 5 years within which the alienation or encumbrance of a homestead is restricted, starts to be computed from the latter date. In Beniga v. Bugas, the court explained that the alienation of lands acquired by homestead or free patent grants is forbidden from the date of approval of the application up to and including the 5th year from and after the date of the issuance of the patent or grant. The latest rulings of the Supreme Court emphasize that the patent is considered issued once the order for its issuance is promulgated and, therefore, the 5-year period is computed from this date and not from the date of registration with the Register of Deeds or from the date of the certificate of title. The provision of law which prohibits the sale or encumbrance of the homestead, except in favor of the government or any of its branches, units or institutions, within 5 years is mandatory. Thus, a sale of homestead within the 5-year prohibitive period is void ab initio and the same cannot be ratified nor can it acquire validity through the passage of time. See approval of Secretary merely directory in Raffinin v. Abel. It was held that the requirement for the approval of the Secretary of Environment and Natural Resources is merely directory, and its absence does not invalidate any alienation, transfer or conveyance of the homestead after 5 years and before the 25-year period. Such approval may be secured at any time in the future. D. Agreements which are considered a circumvention of the law. The prohibition applies as well to the sale of the land to the homesteader's own son or daughter, as a clever homesteader who wants to circumvent the ban may simply sell the lot to his descendant and the latter, after registering the same in his name, would sell it to a third person. In a case, it was held that where the homesteader sold a 2-hectare portion of the homestead to the plaintiffs on the understanding that the actual conveyance of the said portion would be made only after the lapse of the 5-year prohibitory period, the agreement is clearly illegal and void ab initio, as it is intended to circumvent and violate the law. In Manzano v. Ocampo, it was held that the law prohibiting any transfer or alienation of homestead land within 5 years from the issuance of the patent may not distinguish between executory and consummated sales. The rationale against the alienation of a homestead is equally applicable to land acquired under a free patent, except that in the latter, the alienation after 5 years from the order for the issuance of patent does not need the approval of the Secretary. E. Sale of only a part of the land violates prohibition even if only part of the property has been sold or alienated within the prohibited period of 5 years from the issuance of the patent. Such alienation is a sufficient cause for the reversion of the whole estate to the state. As a condition for the grant of a free patent to an applicant, the law requires that the land should not be encumbered, sold or alienated within 5 years from the issuance of the patent. The sale or the alienation of part of the homestead violates that condition. 15. Repurchase by applicant or his heirs. Section 119 of the Public Land Act provides that every conveyance of land acquired under the free patent or homestead provisions, when proper, shall be subject to repurchase by the applicant, his widow, or legal heirs, within a period of 5 years from the date of the conveyance. When the patentee vendor is still living, he has the right to repurchase; otherwise, His widow or his legal heirs have that right. Section 119 is undoubtedly a complement of Section 118. The raison d'etre of the provision is to give the homesteader or patentee every chance to preserve for himself and his family the land that the state had gratuitously given to him as a reward for his labor in cleaning and cultivating it. Its basic objective is to promote public policy, that is, to provide home and decent living for destitutes, aimed at promoting a class of independent small landholders which is the bulwark of peace and order. In keeping with this fundamental idea, the right to repurchase exists not only when the original homesteader makes the conveyance, but also when it is made by his widow or heirs. The right to repurchase attaches to every alienation or encumbrance, and that right can be exercised even in the absence of any stipulation in the deed of sale. 219 The right to repurchase cannot be waived. It is not within the competence of any citizen to barter away what public policy by law seeks to preserve. But where it is established that the intention in exercising the right to repurchase is for the speculative purpose of redeeming the land only to dispose of it again for greater profit, this has been held to be in violation of the policy and spirit of the law. A period of repurchase under Section 119. The 5-year period for a legal redemption starts from the date of the execution of the deed of sale, and not from the date of registration in the office of the Register of Deeds. This is true even if full payment of the purchase price is not made on the date of conveyance, unless there is a stipulation in the deed that ownership shall not vest in the vendee until full payment of the price. The redemption of extrajudicially foreclosed properties, on the other hand, is exercisable within 1 year from the date of the auction sale as provided for in Act Number 3135.223b. Effect of a void conveyance. Section 124 provides that any acquisition, conveyance, alienation, transfer, or other contract made or executed in violation of any of the provisions of Sections 108,120,121,122, and 123 of the Act shall be unlawful and null and void from its execution and shall produce the effect of annulling and cancelling the grant, title, patent, or permit originally issued, recognized or confirmed, actually or presumptively, and cause the reversion of the property and its improvements to the state. Were the parties to a sale of a portion of the public domain covered by homestead patent have been proven to be guilty of having effected the transaction with knowledge of the cause of its invalidity, the sale is null and void and shall cause the reversion of the property to the state. This principle, however, recognizes certain exceptions as where its enforcement or application will run counter to an avowed fundamental policy of public interest. Where the subject of the transaction is a piece of public land, an heir should not be prevented from reacquiring it because it was given by law to her family for her home and cultivation, and this is the policy on which the homestead law is predicated. On the other hand, while the government the proper party to institute an action for the reversion of the property subject of a void sale, does not take steps to assert its title to the homestead, the vendees should not be allowed to remain in it because their right to its possession is no better than that of the vendor or his heirs. While the sale or donation of the land in violation of Section 118 shall cause the reversion of the property to the state, as provided for in Section 124 of the law, such reversion, which could be of the entire land covered by the patent, is a matter between the state and the grantee or his heirs, but does not preclude the heirs from suing to have the alienation declared invalid, for their right to the possession of the land is superior to that of the transferee in the void alienation. Chapter 3 Revised Forestry Code, Presidential Decree No. 705, A. Preliminary 01. Governing Law. The law governing the management and utilization of forest lands is PD No. 705, otherwise known as the Revised Forestry Code of the Philippines. Issued on May 19, 1975, it repeals PD No. 389 or the Forestry Reform Code, Commonwealth Act Number 452 or the Pasture Land Act, and all other laws, orders, rules and regulations or any part thereof which are inconsistent therewith. The law places emphasis not only on the utilization of forest resources but more so on the protection, rehabilitation and development of forest lands, in order to ensure the continuity of their productive condition. It institutes the proper classification and delimitation of the lands of the public domain, and the management, utilization, protection, rehabilitation, and development of forest lands. 2. State policy. The state adopts the following policies. A. The multiple uses of forest lands shall be oriented to the development and progress requirements of the country, the advancement of science and technology, and the public welfare. B. Land classification and survey shall be systematized and hastened. C. The establishment of wood processing plants shall be encouraged and rationalized. And D. The protection, development and rehabilitation of forest land shall be emphasized so as to ensure their continuity and productive condition. 3. Definition of terms. A. Public forest is the mass of lands of the public domain which has not been the subject of the present system of classification for the determination of which lands are needed for forest purposes and which are not. B. Permanent forest or forest reserves refer to those lands of the public domain which have been the subject of the present system of classification and determined to be needed for forest purposes. C. Alienable and disposable lands refer to those lands of the public domain which have been the subject of the present system of classification and declared as not needed for forest purposes. D. Forest lands include the public forest, the permanent forest or forest reserves, and forest reservations. E. Grazing land refers to that portion of the public domain which has been set aside, in view of the suitability of its topography and vegetation, for the raising of livestock. Mineral lands refer to those lands of the public domain which have been classified as such by the Secretary of Natural Resources in accordance with prescribed and approved criteria, guidelines, and procedure. Forest reservations refer to forest lands which have been reserved by the President of the Philippines for any specific purpose or purposes. National Park refers to a forest land reservation essentially of primitive or wilderness character which has been withdrawn from settlement or occupancy and set aside as such exclusively to preserve the scenery, the natural and historic objects and the wild animals or plants therein, and to provide enjoyment of these features in such a manner as will leave them unimpaired for future generations. Game refuge or bird sanctuary refers to a forest land designated for the protection of game animals, birds and fish enclosed to hunting and fishing in order that the excess population may flow and restock surrounding areas. Marine parks refers to any offshore area inhabited by rare and unique species of marine flora and fauna. Seashore park refers to any public shore area delimited for outdoor recreation, sports fishing, water skiing and related healthful activities. 1. Watershed Reservation is a forest land reservation established to protect or improve the conditions of the water yield thereof or reduce sedimentation. Watershed is a land area drained by a stream or fixed body of water and its tributaries having a common outlet for surface runoff. Critical watershed is a drainage area of a river system supporting existing and proposed hydroelectric power and irrigation works needing immediate rehabilitation as it is being subjected to a fast denudation causing accelerated erosion and destructive floods. It is closed from logging until it is fully rehabilitated. 0. Mangrove is a term applied to the type of forest occurring on tidal flat along the seacoast, extending along streams where the water is brackish. Canyon is a portion of the forest land, whether occupied or not, which is subjected to shifting and or permanent/hand-burn cultivation having little or no provision to prevent soil erosion. Forest product means timber, pulp wood, firewood, bark, treetop, resin, gum, wood, oil, honey, beeswax, nipa, rattan, or other forest growth such as grass, shrub, and flowering plant, the associated water, fish, game, scenic, historical, recreational and geological resources in forest lands. Our industrial tree plantation is any tract of forest land purposely and extensively planted to timber crops primarily to supply the raw material requirements of existing or proposed processing plants and related industries. Tree farm refers to any tract of forest land purposely and extensively planted to trees of economic value for their fruits, flowers, leaves, barks, or extractives, but not for the wood thereof. Selective logging means the systematic removal of the mature, overmature and defective trees in such manner as to leave adequate number and volume of healthy residual trees of the desired species necessary to assure a future crop of timber and forest cover for the protection and conservation of soil and water. Lease is a privilege granted by the state to a person, to occupy and possess, in consideration of a specified rental, any forest land of the public domain in order to undertake any authorized activity therein. The license is a privilege granted by the state to a person to utilize forest resources as in any forest land, without any right of occupation and possession over the same, to the exclusion of others, or establish and operate a wood processing plant, or conduct any activity involving the utilization of any forest resources. License agreement is a privilege granted by the state to a person to utilize forest resources within any forest land with the right of possession and occupation thereof to the exclusion of others, except the government, but with the corresponding obligation to develop, protect, and rehabilitate the same in accordance with the terms and conditions set forth in said agreement. Permit is a short-term privilege or authority granted by the state to a person to utilize any limited forest resources or undertake a limited activity with any forest land without any right of occupation and possession therein. The ecosystem means the ecological community considered together with non-living factors and its environment as a unit. Silviculture is the establishment, development or reproduction and care of forest trees. A private right means or refers to titled rights of ownership under existing laws, and in the case of primitive tribes, to rights of possession existing at the time a license is granted under the code, which possession may include places of abode and worship, burial grounds, and old clearings, but excludes production forest inclusive of laid-over areas, commercial forests and established plantations of forest trees and trees of economic value. 2b. Organizational structure. 04. The Department of Environment and Natural Resources, mandate. It is the policy of the state to ensure, for the benefit of the Filipino people, the full exploration and development as well as the judicious disposition, utilization, management, renewal, and conservation of the country's forest, mineral, land, waters, fisheries, wildlife, offshore areas and other natural resources, consistent with the necessity of maintaining a sound ecological balance and protecting and enhancing the quality of the environment and the objective of making the exploration, development, and utilization of such natural resources equitably accessible to the different segments of the present as well as future generations. The Department of Environment and Natural Resources, DENR, shall be primarily responsible for the implementation of the foregoing policy. In the discharge of its responsibility, the DENR shall ensure the availability and sustainability of the country's natural resources through judicious use and systematic restoration or replacement, whenever possible, and increase the productivity of natural resources in order to meet the demands for the products from forest, mineral, land, and water resources of a growing population. 3. Pursuant to Section 4 of VO Number 192 dated June 10, 1987, the DENR shall be the primary government agency responsible for the conservation, management, development and proper use of the country's environment and natural resources, specifically forest and grazing lands, mineral resources, including those in reservation and watershed areas, and lands of the public domain, as well as the licensing and regulation of all natural resources as may be provided for by law in order to ensure equitable sharing of the benefits derived therefrom for the welfare of the present and future generations of Filipinos. A. Policy determination by the executive branch on the proper management of forest resources cannot as a rule be interfered with by the courts and else. Deputy Executive Secretary, petitioner sought the reinstatement of its timber license agreement which was cancelled in August 1983 pursuant to the instructions of the President and memorandum of the then Minister of Natural Resources to stop all logging operations in Nueva Vizcaya and Quirino provinces, in order to conserve the country's remaining forest resources. Sustaining the cancellation of petitioner's timber license agreement, the Supreme Court, through Justice Cortes, held that the legitimacy of such concern can hardly be disputed, explaining, public respondents herein, upon whose shoulders rests the task of implementing the policy to develop and conserve the country's natural resources, have indicated an ongoing department evaluation of all timber license agreements entered into, and permits or licenses issued, under the previous dispensation. In fact, both the executive and legislative departments of the incumbent administration are presently taking stock of its environmental policies with regard to the utilization of timber lands and developing an agenda for future programs for their conservation and rehabilitation. The ongoing administrative reassessment is apparently in response to the renewed and growing global concern over the despoliation of forest lands and the utter disregard of their crucial role in sustaining a balanced ecological system. The legitimacy of such concern can hardly be disputed, most especially in this country. The court takes judicial notice of the profligate waste of the country's forest resources, which has not only resulted in the irreversible loss of flora and fauna peculiar to the region, but has produced even more disastrous and lasting economic and social effects. The delicate balance of nature having been upset, a vicious cycle of floods and droughts has been triggered and the supply of food and energy resources required by the people seriously depleted. Thus, while the administration grapples with the complex and multifarious problems caused by unbridled exploitation of these resources, the judiciary will stand clear. A long line of cases establish the basic rule that the courts will not interfere in matters which are addressed to the sound discretion of government agencies entrusted with the regulation of activities coming under the special technical knowledge and training of such agencies. B. LGU's authority to manage and control communal forests within their territorial jurisdiction is subject to supervision, control and review of the DENR. The critical issue in Rizal v. Sandigan-Bayans is whether the authority to monitor and regulate the transportation of salvaged forest product is solely with the DENR, and no one else. The court ruled that the DENR is not the sole government agency vested with the authority to issue permits relevant to the transportation of salvaged forest products, considering that, pursuant to the General Welfare Clause, LGUs may also exercise such authority. Corollarily, forest lands, although under the management of the DENR, are not exempt from the territorial application of municipal laws, for local government units legitimately exercise their powers of government over their defined territorial jurisdiction. Thus, in Aquino v. Municipality of Malay, Aklan, 6th Court, through Justice Velasco, held that aside from complying with the provisions in the Forest Land Use Agreement for tourism purposes issued by the DENR in favor of Boracay West Cove, it was incumbent on petitioner to likewise comply with the no-build zone restriction under Municipal Ordinance 2,131, which was already in force even before the flag was entered into. Sections 6 and 8 of the ordinance do not exempt petitioner from complying with the restrictions, since these provisions adverted to grant exemptions from the ban on constructions on slopes and swamps, not on the no-build zone. 05. Organization of the Forest Management Bureau. For the purpose of implementing the provisions of the Code, the Bureau of Forestry, the Reforestation Administration, the Southern Cebu Reforestation Development Project, and the Parks and Wildlife Office, including applicable appropriations, records, equipment, property, and such personnel as may be necessary, have been merged into a single agency known as the Forest Management Bureau, formerly Bureau of Forest Development, hereinafter referred to as the Bureau. 7. The Bureau is headed by a director, who is assisted by one or more assistant directors. The director and assistant directors are appointed by the President. A. Supervision. The Bureau is directly under the control and supervision of the Denner Secretary. Upon recommendation of the Director of Forest Development, he shall promulgate rules and regulations necessary to implement the provisions of the Code. 10b. Review. All actions and decisions of the Bureau Director are subject to review, motu proprio or upon appeal of any person aggrieved thereby, by the Denner Secretary, whose decision shall be final and executory after the lapse of 30 days from receipt by the aggrieved party of said decision, unless appealed to the President in accordance with EO number 19, S. of 1966. The decision of the Denner Secretary may not be reviewed by the courts except through a special civil action for certiorari or prohibition. 11. See Exhaustion of Administrative Remedies. The doctrine of exhaustion of administrative remedies calls for resort first to the appropriate administrative authorities in the resolution of a controversy falling under their jurisdiction before the same may be elevated to the courts of justice for review. The theory is that the administrative authorities are in a better position to resolve questions addressed to their particular expertise and that errors committed by subordinates in their resolution may be rectified by their superiors if given a chance to do so. Even if it be assumed that the forestry laws do not expressly require prior resort to administrative remedies, the reasons for the doctrine above given, if nothing else, would suffice to still require its observance. Even if such reasons were disregarded, there would still be the explicit language of pertinent laws vesting in the Denner the power and function to regulate the development, disposition, extraction, exploration and use of the country's forests and to exercise exclusive jurisdiction in the management and disposition of all lands of the public domain, and in the Bureau the responsibility for the enforcement of the forestry laws and regulations here claimed to have been violated. This comprehensive conferment clearly implies at the very least that the Denner should be allowed to rule in the first instance on any controversy coming under its express powers before the courts of justice may intervene. 12. It is important to point out that the enforcement of forestry laws, rules and regulations and the protection, development, and management of forest lands fall within the primary and special responsibilities of the Denner. By the very nature of its function, the Denner should be given a free hand unperturbed by judicial intrusion to determine a controversy which is well within its jurisdiction. The assumption by the trial court, therefore, of a writ in suit filed by private respondents constitutes an unjustified encroachment into the domain of the administrative agency's prerogative. The doctrine of primary jurisdiction does not warrant a court to arrogate unto itself the authority to resolve a controversy the jurisdiction over which is initially lodged with an administrative body of special competence. 13d. Finality of administrative decisions. Laches. It is an established doctrine that the decisions and orders of administrative agencies have, upon their finality, the force and binding effect of a final judgment within the purview of the doctrine of res judicata. These decisions and orders are as conclusive upon the rights of the affected parties as though the same had been rendered by a court of general jurisdiction. The rule of res judicata thus forbids the reopening of a matter once determined by competent authority acting within their exclusive jurisdiction. In Ishmael vs. Deputy Executive Secretary, 15 petitioners' letters to the Office of the President and the Ministry of Natural Resources, MNR, now the Department of Environment and Natural Resources, DENR, dated March 17, 1986 and April 2, 1986, respectively, sought the reconsideration of a memorandum order issued by the Bureau of Forest Development which cancelled its timber license agreement in 1983, as well as the revocation of TLA number 356 subsequently issued by the Bureau to private respondents in 1984. But as gleaned from the record, petitioner did not avail of its remedies under the law, that is, Section 8 of PD number 705, as amended, by attacking the validity of these administrative actions until after 1986. By the time petitioner sent its letter dated April 2, 1986 to the newly appointed Minister of the MNR, requesting reconsideration of the above Bureau actions, these were already settled matters as far as petitioner was concerned. The fact that petitioner failed to seasonably take judicial recourse to have the earlier administrative actions reviewed by the courts through a petition for certiorari was held prejudicial to its cause. Laches is defined as the failure or neglect for an unreasonable and unexplained length of time to do that which by exercising due diligence, could or should have been done earlier, or to assert a right within a reasonable time, warranting a presumption that the party entitled thereto has either abandoned it or declined to assert it. Petitioner's delay constitutes unreasonable and inexcusable neglect, tantamount to laches. 06. Jurisdiction. The Bureau has jurisdiction and authority over all forest lands, grazing lands, and all forest reservations including watershed reservations presently administered by other government agencies or instrumentalities. 16 Forest lands are within the exclusive jurisdiction of the Bureau and beyond the power and jurisdiction of the courts to register under the Torrens system. 17 The Bureau shall be responsible for the a. protection, development, management, regeneration, and reforestation of forest lands, regulation and supervision of the operation of licensees, lessees and permittees for the taking or use of forest products therefrom or the occupancy or use thereof, c. implementation of multiple use and sustained yield management in forest lands, the protection, development and preservation of national parks, marine parks, game refuges and wildlife, d. implementation of measures and programs to prevent gain and managed occupancy of forest and grazing lands, e. the effective, efficient and economic classification of lands of the public domain, and enforcement of forestry, reforestation, parks, game and wildlife laws, rules, and regulations. 18a. Legality of the closure of a logging road is a judicial question. PD number 705 does not vest any power in the Bureau to determine whether or not the closure of a logging road is legal or illegal and to make such determination a prerequisite before an action for damages may be maintained. Whether or not such closure was illegal is a matter to be established on the part of the petitioners and a matter to be disproved by the private respondents. This should appropriately be threshed out in a judicial proceeding. It is beyond the power and authority of the Bureau to determine the unlawful closure of a passageway, much less award or deny the payment of damages based on such closure. Not every activity inside a forest area is subject to the jurisdiction of the Bureau. B. Holder of a pasture lease agreement has right of possession. The grantee of a pasture lease agreement, like HGL Development Corporation, has the right to the lawful possession of the subject property for the period stated in the agreement, and any disturbance of its possession is a valid ground for the issuance of a writ of preliminary mandatory injunction in its favor. The right of HGL to the possession of the property is confirmed by petitioner itself when it sought permission from HGL to use the subject property. Petitioner's possession was merely by tolerance of HGL and only because HGL permitted petitioner to use a portion of the 1983, as well as the revocation of TLA number 356 subsequently issued by the Bureau to private respondents in 1984. But as gleaned from the record, petitioner did not avail of its remedies under the law, that is, Section 8 of PD number 705, as amended, by attacking the validity of these administrative actions until after 1986. By the time petitioner sent its letter dated April 2, 1986 to the newly appointed Minister of the MNR, requesting reconsideration of the above Bureau actions, These were already settled matters as far as petitioner was concerned. The fact that petitioner failed to seasonably take judicial recourse to have the earlier administrative actions reviewed by the courts through a petition for certiorari was held prejudicial to which cause. Laches is defined as the failure or neglect for an unreasonable and unexplained length of time to do that which by exercising due diligence, could or should have been done earlier, or to assert a right within a reasonable time, warranting a presumption that the party entitled thereto has either abandoned it or declined to assert it. Petitioner's delay constitutes unreasonable and inexcusable neglect, tantamount to laches. 06. Jurisdiction. The Bureau has jurisdiction and authority over all forest lands, grazing lands, and all forest reservations including watershed reservations presently administered by other government agencies or instrumentalities. 16 Forest lands are within the exclusive jurisdiction of the Bureau and beyond the power and jurisdiction of the courts to register under the Torrens system. The Bureau shall be responsible for the protection, development, management, regeneration, and reforestation of forest lands, regulation and supervision of the operation of licensees, lessees and permittees for the taking or use of forest products therefrom or the occupancy or use thereof. C. Implementation of multiple use and sustained yield management in forest lands, the protection, development and C. Classification and surveys. 07. Classification. The DENR Secretary shall study, devise, determine and prescribe the criteria, guidelines and methods for the proper and accurate classification and survey of all lands of the public domain into agricultural, industrial or commercial, residential, resettlement, mineral, timber or forest, and grazing lands, and into such other classes as know or may hereafter be provided by law, rules and regulations. He shall determine which of the unclassified lands of the public domain are needed for forest purposes and declare them as permanent forest to form part of the forest reserves. He shall decree those classified and determined not to be needed for forest purposes as alienable and disposable lands, the administrative jurisdiction and management of which shall be transferred to the Bureau of Lands, now Lands Management Bureau. Mangrove and other swamps not needed for shore protection and suitable for fish pond purposes shall be released to, and placed under the administrative jurisdiction and management of, the Bureau of Fisheries and Aquatic Resources. Those still to be classified under the present system shall continue to remain as part of the public forest. 21 Forest lands which have been the subject of pasture leases and permits shall remain classified as forest lands until classified as grazing lands under the criteria, guidelines and methods of classification to be prescribed by the Secretary. The administration, management and disposition of grazing lands shall remain under the Bureau. A. Concept of forests and forest lands. The lexicographers define forest as a large tract of land covered with a natural growth of trees and underbrush, a large wood. The authorities say that the word forest has a significant, not an insignificant meaning, and that it does not embrace land only partly woodland. It is a tract of land covered with trees, usually of considerable extent. The foresters say that no legal definition of forest is practicable or useful. B.H. Baden-Powell, in his work on Forest Law of India, states as follows: every definition of a forest that can be framed for legal purposes will be found either to exclude some cases to which the law ought to apply, or on the other hand, to include some with which the law ought not to interfere. It may be necessary, for example, to take under the law a tract of perfectly barren land which at present has neither trees, brushwood, nor grass on it, but which in the course of time it is hoped will be riboise. But any definition wide enough to take in all such lands, would also take in much that was not wanted. On the other hand, the definition, if framed with reference to tree growth, might and indeed would be almost sure to include a garden, shrubbery orchard, or vineyard, which it was not designed to deal with. 23. There is a big difference between forest as defined in a dictionary and forest or timber land as a classification of lands of the public domain in the Constitution. Section 3, Article 12 of the 1987 Constitution, Section 10, Article 14 of the 1973 Constitution, as amended, and Section 1, Article 13 of the 1935 Constitution. One is descriptive of what appears on the land while the other is a legal status, a classification for legal purposes. 24. The forest land started out as a forest or vast tracts of wooded land with dense growths of trees and underbush. However, the cutting down of trees and the disappearance of virgin forest did not automatically convert the lands of the public domain from forest or timber land to alienable agricultural land. Forests, in the context of both the Public Land Act and the Constitution classifying lands of the public domain into agricultural, forest or timber, mineral lands and national parks, do not necessarily refer to a large tract of wooded land or an expanse covered by dense growth of trees and underbrush. As expounded by the court in Heirs of Amunatgi v. Director of Forestry. A forested area classified as forest land of the public domain does not lose such classification simply because loggers or settlers may have stripped it of its forest cover. Parcels of land classified as forest land may actually be covered with grass or planted to crops by cane cultivators or other farmers. Forest lands do not have to be on mountains or in out-of-the-way places. Swampy areas covered by mangrove trees, nipa palms, and other trees growing in brackish or seawater may also be classified as forest land. The classification is descriptive of its legal nature or status and does not have to be descriptive of what the land actually looks like. Unless and until the land classified as forest is released in an official proclamation to that effect so that it may form part of the disposable agricultural lands of the public domain, the rules on confirmation of imperfect title do not apply. Emphasis supplied. B. Public forests or forest reserves are not capable of private appropriation. Public forest lands or forest reserves, unless declassified and released by positive act of the government so that they may form part of the disposable agricultural lands of the public domain, are not capable of private appropriation. As to these assets, the rules on confirmation of imperfect title do not apply. Under Section 2, Article 12 of the Constitution, which embodies the Regalian Doctrine, all lands of the public domain belong to the state as source of any asserted right to ownership of land. All lands not appearing to be clearly of private dominion presumptively belong to the state. Accordingly, public lands not shown to have been reclassified or released as alienable agricultural land or alienated to a private person by the state remain part of the inalienable public domain. Under Section 6 of the Public Land Act, the prerogative of classifying or reclassifying lands of the public domain, that is, from forest or mineral to agricultural and vice versa, belongs to the executive branch of the government and not the court. Needless to stress, the onus to overturn, by incontrovertible evidence, the presumption that the land subject of an application for registration is alienable or disposable rests with the applicant. It cannot be overemphasized that unwarranted appropriation of public lands has been a notorious practice resorted to in land registration cases. For this reason, the court has made it a point to stress, when appropriate, that declassification of forest and mineral lands, as the case may be, and their conversion into alienable and disposable lands need an express and positive act from the government. 4. Unclassified land cannot be acquired by adverse occupation or possession. Occupation thereof in the concept of owner, however long, cannot ripen into private ownership and be registered as title. See the APR converts ancestral lands as public agricultural lands for registration purposes. However, for purposes of registration, RA number 8371, or the Indigenous Peoples' Rights Act, APR expressly converts ancestral lands into public agricultural land which may be disposed by the state. Hence, There is no need to secure a separate certification that the ancestral land is A&D in character, it being sufficient to show that the land is duly identified, delimited, and certified as such. D. Topography. No land of the public domain 18% in slope or over shall be classified as alienable and disposable, nor any forest land 50% in slope or over, as grazing land. Lands 18% in slope or over which have already been declared as alienable and disposable shall be reverted to the classification of forest lands by the Dinner Secretary, to form part of the forest reserves, unless they are already covered by existing titles or approved public land applications, or actually occupied openly, continuously, adversely, and publicly for a period of not less than 30 years as of the effectivity of the Code, where the occupant is qualified for a free patent under the Public Land Act Commonwealth Act Number 141, as amended. E. Areas needed for forest purposes. The following lands, even if they are below 18% in slope, are needed for forest purposes, and may not, therefore, be classified as alienable and disposable land, to wit, a. Areas less than 250 hectares which are far from, or are not contiguous with, any certified alienable and disposable land. B. Isolated patches of forest of at least 5 hectares with rocky terrain, or which protect a spring for communal use. C. Areas which have already been reforested. D. Areas within forest concessions which are timbered or have good residual stocking to support an existing, or approved to be established, wood processing plant. E. Ridgetops and plateaus regardless of size found within, or surrounded wholly or partly by, forest lands where headwaters emanate, appropriately located road rights or way. G. 20-meter strips of land along the edge of the normal high water line of rivers and streams with channels of at least 5 meters wide. H. Strips of mangrove or swamplands at least 20 meters wide, along shorelines facing oceans, lakes, and other bodies of water, and strips of land at least 20 meters wide facing lakes. 1. Areas needed for other purposes, such as national parks, national historical sites, game refuges and wildlife sanctuaries, forest station sites, and others of public interest. And D. Areas previously proclaimed by the President as forest reserves, national parks, game refuge, bird sanctuaries, national shrines, national historic sites. In case an area falling under any of the foregoing categories shall have been titled in favor of any person, steps shall be taken, if public interest so requires, to have said title cancelled or amended, or the titled area expropriated. F. Mangrove swamps are in the category of forest lands. Mangrove swamps or manglers should be understood as comprised within the public forests of the Philippines. The classification of mangrove swamps as forest lands is descriptive of its legal nature or status and does not have to be descriptive of what the land actually looks like. Mangrove swamps could not therefore be the subject of the adverse possession and consequent ownership. They must first be released as forest land and reclassified as agricultural land by the Director of Forest Development. The mere existence of a survey plan of mangrove swamps approved by the Director of Lands would not have the effect of converting the mangrove swamps, as forest land, into agricultural land. The Director of Lands has no authority to dispose of the same under the Public Land Act. It is the Director of Forest Development who has the authority to determine whether forest land is more valuable for agricultural rather than forestry uses, as a basis for its declaration as agricultural land and release for private ownership. 33 The Bureau of Fisheries and Aquatic Resources has no jurisdiction to administer or dispose of swamplands or mangrove lands forming a part of the public domain until such lands have been released for fishery or other purposes. G. Forest lands are not registrable in Nixon v. Secretary of Agriculture. 35 It was held that until timber or forest lands are released as disposable and alienable, Neither the Lands Management Bureau nor the Bureau of Fisheries and Aquatic Resources has authority to lease, grant, sell, or otherwise dispose of these lands for homesteads, sales patents, leases for grazing or other purposes, fish pond leases, and other modes of utilization. The Bureau of Fisheries and Aquatic Resources has no jurisdiction to administer and dispose of swamplands or mangrove lands forming part of the public domain while such lands are still classified as forest land or timberland and not released for fishery or other purposes. If the land forms part of the public forest, possession thereof, no matter how long, cannot convert it into private property as it is within the exclusive jurisdiction of the Bureau and beyond the power and jurisdiction of the registration court. There can be no imperfect title to be confirmed over lands not yet classified as disposable or alienable. Declassification of forest land is an express and positive act of government. It cannot be presumed. Neither should it be ignored nor deemed waived. As ruled in the case of Republic vs. Court of Appeals and Currents, it is already a settled rule that forest lands or forest reserves are not capable of private appropriation and possession thereof, however long, cannot convert them into private property. Vano vs. Government of Philippine Islands, 41 Phil. 161, Adorable vs. Director of Forestry, 107 Phil. 401. Director of Forestry vs. Munoz, 23 Supreme Court Reports annotated 1183, Republic vs. De La Cruz, 67 Supreme Court Reports annotated 221, Director of Lands vs. Reyes and Alanson Urine vs. Director of Lands, 68 Supreme Court Reports annotated 177, Republic vs. Court of Appeals, 89 Supreme Court Reports annotated 648, and Director of Lands vs. Court of Appeals, 133 Supreme Court Reports annotated 701 unless such lands are reclassified and considered disposable and alienable by the Director of Forestry, but even then, possession of the land by the applicants prior to the reclassification of the land as disposable and alienable cannot be credited as part of the 30-year requirement under Section 48B of the Public Land Act. Director of Lands vs. Court of Appeals, Supra. 30 portion of that land, earn credits towards an eventual confirmation of imperfect title. The government must first declare the forest land to be alienable and disposable agricultural land before the year of entry, cultivation, and exclusive and adverse possession can be counted for purposes of an imperfect title. The court in Republic vs. Court of Appeals and Burnham 39 similarly held. Moreover, it is well settled that a certificate of title is void when it covers property of public domain classified as forest or timber and mineral lands. Any title issued on non-disposable lots even in the hands of an alleged innocent purchaser for value, shall be cancelled. Lepanto Consolidated Mining Company vs. Dumont, Supreme Court Reports annotated 540, 1979 underscoring supplied. In the case at bar, it will be noted that in granting titles to the land in dispute, the lower court counted the period of possession of private respondents before the same were released as forest lands for disposition, which release is tantamount to qualifying the latter to a grant on said lands while they were still non-disposable. Thus, under the foregoing rulings, even assuming that the transferees are innocent purchasers for value, their titles to said lands derived from the titles of private respondents which were not validly issued as they cover lands still a part of the public domain, may be cancelled. The case of Republic vs. Nagiado affirms the foregoing principles. The court, through Justice Garcia, held that public forest lands or forest reserves, unless declassified and released by positive act of the government so that they may form part of the disposable agricultural lands of the public domain, are not capable of private appropriation. As to these assets, the rules on confirmation of imperfect title do not apply. Under Section 2, Article 12 of the Constitution, which embodies the Regalian Doctrine, All lands of the public domain belong to the state as source of any asserted right to ownership of land. All lands not appearing to be clearly of private dominion presumptively belong to the state. Accordingly, public lands not shown to have been reclassified or released as alienable agricultural land or alienated to a private person by the state remain part of the inalienable public domain. It cannot be overemphasized that unwarranted appropriation of public lands has been a notorious practice resorted to in land registration cases. For this reason, the court has made it a point to stress, when appropriate, that declassification of forest and mineral lands, as the case may be, and their conversion into alienable and disposable lands need an express and positive act from the government. Reservations and forest lands and offshore areas. The President may establish within any lands of the public domain, forest reserve and forest reservation for the national park system, for preservation as critical watersheds, or for any other purpose, and modify boundaries of existing ones. The General Secretary may reserve and establish any portion of the public forest or forest reserve as site or experimental forest for use of the Forest Research Institute. When public interest so requires, any offshore area needed for the preservation and protection of its educational, scientific, historical, ecological and recreational values including the marine life found therein, shall be established as marine parks. 41a. Reservation of land, covered by a timber concession, for experiment station vests in the grantee full ownership thereof in International Hardwood and Veneer Company vs. University of the Philippines. 42. The President issued a proclamation withdrawing from the sale and settlement, and reserving for the University of the Philippines up as experiment station for its research and science functions, a parcel of land of the public domain, with an area of 3,500 hectares. Subsequently, RA No. 3990 was enacted reserving the same land for the same purpose. Pursuant to this law, the reserved area was ceded and transferred in full ownership to the University of the Philippines subject to any existing concessions, if any. The above reservation, however, happened to be within the area covered by petitioner's timber license. Petitioner thus subsequently filed a petition seeking a declaration that UP does not have the right to supervise and regulate the cutting and removal of timber and other forest products, to scale, measure and seal the timber, cut and or to collect forest charges, reforestation fees and royalties from petitioner and or impose any other duty or burden upon the latter over that portion covered by its license agreement. Has UP the authority to collect forest charges or to supervise the operation by the petitioner of the timber concession affected by any act? Answering the issue in the affirmative, the court ruled that when the Republic ceded and transferred the property to UP, it completely removed said land from the public domain and, in respect to the area covered by the timber license of petitioner, removed and segregated it from a public forest, it divested itself of its rights and title thereto and relinquished and conveyed the same to the UP, and made the latter the absolute owner thereof, subject only to the existing concession. The proviso regarding existing concessions refers to the timber license of petitioner. But all that it means, however, is that the right of petitioner as a timber licensee must not be affected, impaired or diminished but must be respected. However, insofar as the Republic is concerned, all its rights as grantor of the license were effectively assigned, ceded and conveyed to UP as a consequence of the above transfer of full ownership. The area in question having been, in effect, converted into a registered private woodland, the authority and jurisdiction of the Bureau of Forestry over it were likewise terminated. However, petitioner as licensee or grantee, may continue to cut, collect, and remove timber from the area ceded and transferred to UP until its concession expires, but the forest charges or royalties shall now be paid to the new owner, the UP. Utilization and management. 9. Multiple use. Only the utilization, exploitation, occupation, or possession of any forest land, or any activity therein, involving one or more of its resources, which will produce the optimum benefits to the development and progress of the country and the public welfare, without impairment or with the least injury to its other resources, shall be allowed. Critical watersheds and national parks shall not be subject to logging operations. A. Preservation and protection of forests. Adherence to public policy should be followed with respect to forest lands. Consonantly, in Director of Forestry versus Munoz, the court, through Justice Sanchez, articulated on the need to preserve and protect forests, viz., many have written much, and many more have spoken, and quite often, about the pressing need for forest preservation, conservation, protection, development and reforestation. Not without justification. For forests constitute a vital segment of any country's natural resources. It is of common knowledge by now that absence of the necessary green cover on our lands produces a number of adverse soil effects of serious proportions. Without the trees, watersheds dry up, rivers and lakes which they supply are emptied of their contents. The fish disappear. Denuded areas become dust bowls. As waterfalls cease to function, so will hydroelectric plants. With the rains, the fertile topsoil is washed away, geological erosion results. With erosion come the dreaded floods that wreak havoc and destruction to property, crops, livestock, houses and highway, not to mention precious human lives. Indeed, the foregoing observation should be written down in a lumberman's decalogue. And in Ramos versus Director of Lands, 45 Justice Malcolm stated, indubitably, there should be conservation of the natural resources of the Philippines. The prodigality of the spendthrift who squanders his substance for the pleasure of the fleeting moment must be restrained for the less spectacular but surer policy which protects nature's wealth for future generations. B. Principle of intergenerational responsibility. A paradigm which would even qualify as an ideology of the new age is the protection of the environment. The petition in Oposa versus Factorini bears upon the constitutional right of Filipinos to a balanced and healthful ecology, which the petitioners dramatically factor and not Factorini associate with the twin concepts of intergenerational responsibility and intergenerational justice. Specifically, it touches on the issue of whether petitioners have a cause of action to prevent the misappropriation or impairment of Philippine rainforests and arrest the unabated hemorrhage of the country's vital life support systems and continued rape of Mother Earth, citing the adverse and disastrous consequences of deforestation and the mismanagement of the country's forests. Petitioner minors, represented by their parents and guardians, prayed that respondents be ordered to cancel all existing timber license agreements in the country and cease and desist from accepting and approving new timber license agreements. They alleged that deforestation has resulted in a host of environmental tragedies, such as a water shortages resulting from the drying up of the water table, desalinization of the water, sea massive erosion and the consequential loss of soil fertility and agricultural productivity. The endangering and extinction of the country's unique, rare and varied flora and fauna, the disturbance and dislocation of cultural communities, the siltation of rivers and seabeds and consequential destruction of corals and other aquatic life, increasing velocity of typhoon winds which result from the absence of windbreakers, the flooding of lowlands and agricultural plains arising from the absence of the absorbent mechanism of forests, the siltation and shortening of the lifespan of multi-billion peso dams, and the reduction of the Earth's capacity to process carbon dioxide gases, which has led to perplexing and catastrophic climatic changes such as the phenomenon of global warming, otherwise known as the greenhouse effect. Petitioners maintain that the granting of the timber license agreements TLAs violated their right to a balanced and healthful ecology, hence, the full protection thereof requires that no further TLAs should be renewed or granted. Finding merit in the petition, the court, through Justice Davide, stressed the right of the people to a balanced and healthful ecology as explicitly mandated by Section 16, Article 2 of the Constitution, to wit, Section 16. The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. The basic rights to a balanced and healthful ecology and to health are mandated as state policies by the Constitution itself, thereby highlighting their continuing importance and imposing upon the state a solemn obligation to preserve the first and protect and advance the second, for the day would not be too far when all else would be lost not only for the present generation, but also for those to come generations which stand to inherit nothing but parched earth incapable of sustaining life. The court further ruled that the right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment. The said right implies, among many other things, the judicious management and conservation of the country's forests. Without such forests, the ecological or environmental balance would be irreversibly disrupted. Every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Put a little differently, the miners' assertion of their right to a sound environment constitutes, at the same time, the performance of their obligation to ensure the protection of that right for the generations to come. On respondents' allegation that the cancellation of existing TLAs would violate the non-impairment clause of the Constitution, the court held that all licenses may be revoked or rescinded by executive action. A license is not a contract, property or a property right protected by the Due Process Clause of the Constitution. It can be withdrawn or cancelled in the exercise of the police power of the state. C. A timber license is not a contract but a mere privilege which does not create irrevocable rights. In Tan v. Director of Forestry, 47. The court, through Justice Mackay, stressed the state's policy for the preservation and conservation of the natural resources and, in particular, the country's watersheds. It sustained the cancellation by the Director of Forestry of petitioner's timber license which practically comprises the entire along the Po watershed. The court explained that watersheds serve as a defense against soil erosion and guarantees the steady supply of water. The Constitution expressly mandates the conservation and proper utilization of natural resources. Watersheds in the Philippines had been subjected to rampant abusive treatment due to various unscientific and destructive land use practices. Once lush watersheds were wantonly deforested due to uncontrolled timber cutting by licensed concessionaries and illegal loggers. This is one reason why the terms and conditions of timber licenses usually stipulate that they are subject to change or may be made to expire at an earlier date, when public interests so require. In any case, a timber license is an instrument by which the state regulates the utilization and disposition of forest resources to the end that public welfare is promoted. A timber license is not a contract. Within the purview of the Due Process Clause, it is only a license or privilege, which can be validly withdrawn whenever dictated by public interest or public welfare. The granting of license does not create irrevocable rights, neither is it property or property rights. Similarly, it was held in Ishmael v. Deputy Executive Secretary that timber licenses, permits and license agreements are the principal instruments by which the state regulates the utilization and disposition of forest resources to the end that public welfare is promoted. And it can hardly be gainsaid that they merely evidence a privilege granted by the state to qualified entities, and do not vest in the latter a permanent or irrevocable right to the particular concession area and the forest products therein. They may be validly amended, modified, replaced or rescinded by the chief executive when national interests so require. Thus, they are not deemed contracts within the purview of the Due Process of Law Clause. In the same vein, a presidential warranty cannot be considered a contract distinct from a timber license agreement (TLA) or an integrated forest management agreement (FMA). The warranty covers only the right to cut, collect, and remove timber in a concession area, and does not extend to the utilization of other resources, such as mineral resources, occurring within the concession. As clarified in Republic v. Pagadian City Timber Company Incorporated, ANFMA is defined as a privilege granted by the state to a person to utilize forest resources within any forest land with the right of possession and occupation thereof to the exclusion of others, except the government, but with the corresponding obligation to develop, protect and rehabilitate the same in accordance with the terms and conditions set forth in said agreement. Jurisprudence has been consistent in holding that license agreements are not contracts within the purview of the due process and the non-impairment of contracts clauses enshrined in the Constitution. 10. License agreement, license, lease or permit. No person may utilize, exploit, occupy, possess or conduct any activity within any forest land, or establish and operate any wood processing plant, unless he has been authorized to do so under a license agreement, lease, license, or permit. The licensee takes his license subject to such conditions as the grantor sees fit to impose, including its revocation at pleasure. Timber 11. Duration of license agreement or license to harvest timber in forest lands. The duration of the privilege to harvest timber in any particular forest land under a license agreement or license shall be fixed and determined in accordance with the annual allowable cut therein, the established cutting cycle thereof, the yield capacity of harvestable timber, and the capacity of healthy residuals for a second growth. The privilege shall automatically terminate, even before the expiration of the license agreement of license, the moment the harvestable timber have been utilized without leaving any laid over area capable of commercial utilization. The maximum period of any privilege to harvest timber is 25 years, renewable for a period, not exceeding 25 years, necessary to utilize all the remaining commercial quantity or harvestable timber either from the unlogged or logged over area. It shall be a condition for the continued privilege to harvest timber under any license or license agreement that the licensee shall reforest all the areas which shall be determined by the Bureau. 12. Size of forest concessions. The size of the forest lands which may be the subject of timber utilization shall be limited to that which a person may effectively utilize and develop for a period of 50 years, considering the cutting cycle, the past performance of the applicant and his capacity not only to utilize but, more importantly, to protect and manage the whole area, and the requirements of processing plants existing or to be installed in the region. Reforestation 13. Forest lands to be reforested. The following shall be reforested and covered with suitable and sufficient trees, to wit: a bare or grass-covered tracts of forest lands with at least 50% slope, b. bare or grass-covered tracts of forest lands with less than 50% slope, but with soil so highly erodible as to make grass cover inadequate for soil erosion control, c. brushlands or tracts of forest lands generally covered with brush, which need to be developed to increase their productivity. D. Open tracts of forest lands with slopes or gradients generally exceeding 50%, interspersed with patches of forest each of which is less than 250 hectares in area, denuded or inadequate timbered areas proclaimed by the President as forest reserves and reservations as critical watersheds, national parks, game refuge, bird sanctuaries, national shrines, national historic sites. Inadequately stocked forest lands within forest concessions, g. portions of areas covered by pasture leases or permits having a slope of at least 50%, and h. river banks, easements, road rights-of-ways, deltas, swamps, former river beds, and beaches. 14. Industrial tree plantations and tree farms. A lease for a period of 25 years, renewable for another period not exceeding 25 years, for the establishment of an industrial tree plantation or a tree farm may be granted by the DENR, upon recommendation of the Director, to any person qualified to develop and exploit natural resources, over timber or forest lands of the public domain with a minimum area of 1,000 hectares for industrial tree plantation and 100 hectares for tree farm. No lease shall be granted within critical watersheds. G. Forest protection 15. Control of concession area. in order to achieve the effective protection of the forest lands and the resources thereof from illegal entry, unlawful occupation, cannon, fire, insect infestation, theft, and other forms of forest destruction. The utilization of timber therein shall not be allowed except through license agreements under which the holders thereof shall have the exclusive privilege to cut all the allowable harvestable timber in their respective concessions, and the additional right of occupation, possession, and control over the same, to the exclusive of all others, except the government, but with the corresponding obligation to adopt all the protection and conservation measures to ensure the continuity of the productive condition of said areas, conformably with multiple use and sustained yield management. If the holder of a license agreement over a forest area expressly or impliedly waives the privilege to utilize any softwood, hardwood or mangrove species therein, a license may be issued to another person for the harvest thereof without any right of possession or occupation over the areas where they are found, but he shall, likewise, adopt protection and conservation measures consistent with those adopted by the license agreement holder in the said areas. 16. Regulation of timber utilization in all other classes of lands and of wood processing plants. The utilization of timber in alienable and disposable lands, private lands, civil reservations, and all lands containing standing or felled timber, including those under the jurisdiction of other government agencies, and the establishment and operation of sawmills and other wood processing plants, shall be regulated in order to prevent them from being used as shelters for excessive and unauthorized harvests in forest lands, and shall not therefore be allowed except through a license agreement, license, lease or permit. 17. Swamplands and mangrove forests. Strips of mangrove forest bordering numerous islands which protect the shoreline roads, and even coastal communities from the destructive force of the sea during high winds and typhoons, shall be maintained and shall not be alienated. Such strips must be kept from artificial obstruction so that flood water will flow unimpeded to the sea to avoid flooding or inundation of cultivated areas in the upstream. All mangrove swamps set aside for coast protection purposes shall not be subject to clear-cutting operation. Mangrove and other swamps released to the Bureau of Fisheries and Aquatic Resources for fish pond purposes which are not utilized, or which have been abandoned for 5 years from the date of such release, shall revert to the category of forest land. 18. Visitorial power. The General Secretary, by himself or through the Director or any qualified representative, may investigate, inspect and examine records, books and other documents relating to the operation of any holder of a license agreement, license, lease, or permit, and its subsidiary or affiliated companies, to determine compliance with the terms and conditions thereof, the revised Forestry Code and other pertinent laws and regulations. 19. Authority of forest officers. When in the performance of their official duties, forest officers, or other government officials or employees duly authorized by the Secretary or Director, shall have free entry into areas covered by a license agreement, license, lease or permit. Forest officers are authorized to administer oath and take acknowledgment in official matters connected with the functions of their office, and to take testimony in official investigations conducted under the authority of the Code and the implementing rules and regulations. 20. Mining operations. Mining operations in forest lands shall be regulated and conducted with due regard to protection, development, and utilization of other surface resources. Location, prospecting, exploration, utilization or exploitation of mineral resources in forest reservations shall be governed by mining laws, rules and regulations. No location, prospecting, exploration, utilization, or exploitation of mineral resources inside forest concessions shall be allowed unless proper notice has been served upon the licensees thereof and the prior approval of the Director, secured. 21. Mineral reservations. Mineral reservations which are not the subject of mining operations or where operations have been suspended for more than 5 years shall be placed under forest management by the Bureau. Mineral reservations where mining operations have been terminated due to the exhaustion of its minerals shall revert to the category of forest land, unless otherwise reserved for other purposes. H. Special uses 22. Pasture and forest lands. No forest land 50% in slope or over may be utilized for pasture purposes. Forest lands which are being utilized for pasture shall be maintained with sufficient grass cover to protect soil, water, and other forest resources. The size of forest lands that may be allowed for pasture and other special uses shall be determined by rules and regulations. 23. Wildlife. Wildlife may be destroyed, killed, consumed, eaten or otherwise disposed of, without the necessity of permit, for the protection of life, health, safety and property, and the convenience of the people. However, the Director may regulate the killing and destruction of wildlife and forest lands in order to maintain an ecological balance of flora and fauna. 24. Recreation. The Bureau shall, in the preparation of multi-use management plans, identify and provide for the protection of scenic areas in all forest lands which are potentially valuable for recreation and tourism, and plan for the development and protection of such areas to attract visitors thereto and meet increasing demands therefor. The construction and operation of necessary facilities to accommodate outdoor recreation shall be done by the Bureau with the use of funds derived from rentals and fees for the operation and use of recreational facilities by private persons or operators, in addition to whatever funds may be appropriated for such purposes. 25. Other special uses of forest lands. Forest lands may be leased for a period not exceeding 25 years, renewable upon the expiration thereof for a similar period, or held under a permit, for the establishment of sawmills, lumber yards, timber depots, logging camps, rights-of-way, or for the construction of sanatoria, bathing establishments, camps, salt works, or other beneficial purposes which do not in any way impair the forest resources therein. 68. Qualifications 26. Diffusion of benefits. The privilege to utilize, exploit, occupy, or possess forest lands, or to conduct any activity therein, or to establish and operate wood processing plants, shall be diffused to as many qualified and deserving applicants as possible. 69. In the evaluation of applications of corporations, increased Filipino equity and participation beyond the 60% constitutional limitation shall be encouraged. All other factors being equal, the applicant with more Filipino equity and participation shall be preferred. 70. 27. Service contracts. The Secretary may, in the national interest, allow forest products licensees, lessees, or permittees to enter into service contracts for financial, technical, management, or other forms of assistance, in consideration of a fee, with any foreign person or entity for the exploration, development, exploitation or utilization of the forest resources, covered by their license agreements, licenses, leases or permits. Existing valid and binding service contracts for financial, technical, management or other forms of assistance are hereby recognized as such. Pursuant to EO number 278, dated July 25, 1987, and until Congress otherwise provides, the General Secretary is authorized to negotiate and enter into, for and in behalf of the government, joint venture, co-production, or production sharing agreements for the development and utilization of forest lands and/or forest resources with any Filipino citizen, or corporation, or association, at least 60% of whose capital is owned by Filipino citizens. Such agreements may be for a period not exceeding 25 years, renewable for not more than 25 years, and shall conform with and include the minimum terms and conditions prescribed in Section 5 of the EO. J. Criminal offenses and penalties 28. Cutting, gathering and/or collecting timber or other products without license. Section 68, PD number 705, as amended by EO number 277, dated July 25, 1987, provides. Section 68. Cutting, gathering and/or collecting timber, or other forest products without license. Any person who shall cut, gather, collect, remove timber or other forest products from any forest land, or timber from alienable or disposable public land, or from private land, without any authority, or possess timber or other forest products without the legal documents as required under existing forest laws and regulations, shall be punished with the penalties imposed under Articles 309 and 310 of the Revised Penal Code, provided that in the case of partnerships, associations, or corporations, the officers who ordered the cutting, gathering, collection or possession shall be liable, and if such officers are aliens, they shall, in addition to the penalty, be deported without further proceedings on the part of the Commission on Immigration and Deportation. The court shall further order the confiscation in favor of the government of the timber or any forest products cut, gathered, collected, removed, or possessed, as well as the machinery, equipment, implements and tools illegally used in the area where the timber or forest products are found. EO number 277 further added sections 68A and 68B, which read as follows. Section 68A. Administrative authority of the department head or his duly authorized representative. 601 to order confiscation. In all cases of violations of this code or other forest laws, rules and regulations, the department head or his duly authorized representative may order the confiscation of any forest products illegally cut, gathered, removed or possessed or abandoned, and all conveyances used either by land, water or air in the commission of the offense, and to dispose of the same in accordance with pertinent laws, regulations or policies on the matter. Section 68B. Rewards to informants. Any person who shall provide any information leading to the apprehension and conviction of any offender for any violation of this code or other forest laws, rules and regulations, or confiscation of forest products shall be given a reward in the amount of 20% and 20% of the proceeds of the confiscated forest products. Conveyance is any mode or type or class of vehicle or craft or any other means used for transportation either on land, water, air, or any combination thereof, whether motorized or not, used for or in taking and or maintaining temporary or permanent possession or control, gathering, collecting, processing, disposing of, or otherwise transporting, moving or transferring illegal forest products. Forest products refers to timber including lumber, pulp wood, firewood, bark, treetop, resin, gum, wood, oil, honey, beeswax, nipa,